Good morning. I'm early. Court is early, so I jumped on early. Let's see if we have alien issues. Share screen. Let's see.
Started as usual.
Let's see. Oops.
You should be signing in on that one.
Oops.
No, go to the Division B meeting down there, the recurring meeting to the left. Yeah, that one, not child, that one. That should do it. Right.
Let's see. So far, this is working.
Yep, you got them joining now.
Hoping there's no internet issues.
Yeah. Let me just get out and start.
There may be internet issues. If there is, we'll figure it out.
No, I think it's fine.
If there is.
They probably use that for closings.
Shh. All right, I've got this going. Let me get on real quick and I'll open up the chat. Sorry, they said yesterday 1 o'clock. So I thought we had time. Edit, customize, live chat, save. All right, chat should be open.
All right, now that we've got the technical stuff out of the way, we are back in session on State versus Ferriter. Let me have appearances, please.
Good morning.
Okay, all sides ready to continue with the discussion that we started yesterday afternoon regarding the jury instructions.
Good morning.
It seems like we are on the same page. Everything, I took out the burden of proof for the defense. I kept it for the state.
So here's the question I have after, and I read this very carefully and looked at it probably more than I should. But I came away after reading Radford with the feeling that in this particular case where I've motion for JOA by the defense to just that prong in the information that dealt with the confinement and the caging that did not involve bodily injury and did not involve corporal punishment, I came away with the feeling that the defense does not apply with what's left of count one, but it would apply to the lesser. And in looking at the draft of the instructions, it seems to me the defense is included both as to the charge of aggravated assault and to the lesser, but my reading of the law is that it doesn't apply now to count one as it currently stands with how I've narrowed it. So let me hear both sides weigh in on that. And I apologize if I'm raising an issue that both of you hadn't looked at, but that's something that jumped out at me as I looked at this.
So that did occur. Yes, that I agree, Your Honor. That did occur to the state because there's no
corporal punishment that's involved in count one anymore.
Right. It's not corporal punishment. It's not reasonable punishment, and it's also not physical punishment. However, jury instructions are sometimes a way in which a case can be reversed. And so,
well, if the state is telling me that you don't want to take a chance and you want it to be included, I won't get in the way of that. But I'm telling you, sitting up here on the bench and looking at the case law, in light of how I've narrowed the case on the count one, I don't think the affirmative defense of corporal punishment, a permissible corporal punishment, applies to count one. It clearly applies to the lesser. That's not even an issue for me. And I will say that you've drafted, even in count one, you've drafted the instruction the way I would have ordered it this morning, putting the burden of persuasion on the state. In light of everything I looked at, that would be where I would place the burden under the case law. There's no perfect guidance on that, but that's kind of, I'm doing the same thing that you're doing, being cautious and putting the burden on the state so that if there's any error, it's something that shouldn't be harmful to the defendant.
Right. Yeah. I mean, so we put it in because the defense was requesting it. Let me think about it if we want to remove it for a second. I certainly was going to argue that it doesn't apply as charged, but we'll see what the defense has to say.
All right, so let me hear from you, Mr. Waheed. You moved successfully for JOA on a portion of count 1, which knocked out the great bodily harm aspect of that, in which in the court's view left me with, as far as count 1 goes, with that prong that I read when we were discussing the issue that dealt with the confinement and the caging that did not involve physical punishment. So by you being successful in that portion of your motion for JOA, what's your position now in terms of what I've stated, that I don't think that the affirmative defense applies as presently stands with the count 1 for aggravated battery or aggravated child abuse? I'm sorry.
Sure. Obviously, my position is it does apply.
But let me ask you, tell me, because if count, you agree that the aggravated child abuse count now does not involve any corporal punishment aspect, right? And the affirmative defense relates to permissible corporal punishment, doesn't it?
No, it's physical discipline, Judge. The actual wording is, it is not a crime
He's
for a
picking her
parent or
nose.
a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline.
All right, so your position is that the caging is the physical discipline,
Correct.
but it doesn't have to be corporal. I'm not sure I agree with that, but I understand your position. So if that's your position, I can see where you would argue that it comes and applies to count 1 as well, even with the way that I've narrowed it.
Yes, correct. And the instruction as it goes on is, it doesn't say anything about corporal punishment, to be clear. It does say physical discipline, and it's talking about whether or not it was reasonable. I think that is exactly the situation we are in right now. So I do think it applies. Every case I've read, I'm not sure where the court felt it didn't apply.
The what didn't apply?
That this affirmative defense would not apply in this case.
No, I feel that it doesn't apply to count 1 for aggravated child abuse, but that it would apply for any lesser of that. And let me tell you why I get to that, and you can deal with it specifically. Because when I looked at the Radford decision, the Supreme Court of Florida makes the statement as follows: we agree with the 4th and 2nd districts that under the current statutory scheme, there is no parental privilege barring prosecution for felony child abuse under section 827.03. Then they go on and say, indeed, section 827.031 defining felony child abuse makes no exceptions for parents or the equivalent. And then they say this, and this is what leads me to my conclusion about if the count doesn't involve corporal punishment as it presently stands, then maybe the affirmative defense doesn't apply. And this is what the Supreme Court said. Thus, it is not that felony child abuse by a parent is a non-existent crime, but rather a parent may assert as an affirmative defense his or her parental right to administer reasonable and non-excessive corporal punishment. So the Supreme Court spoke to corporal punishment, and I believe that caging doesn't, at least I wouldn't define it off the top of my head as being corporal punishment. Corporal punishment in my mind is physical touching, and as the cases talk about a permissible battery upon a child subject to the reasonableness limitation. So let me have you address that, because that's what led me to the conclusion why I raised the issue right up front as to whether it applies at all to the top level charge.
Yes. So that case, Radford, is before the amended jury instruction. So this jury instruction is actually later in time approved by the Supreme Court. And the jury instruction sits under 16.1 and under 16.3. It does not caveat in any way using the word corporal punishment anywhere. And it doesn't say, it doesn't apply to any of either A, B, C, or D. under aggravated
Yes.
child abuse. So A and D are gone, I believe. We're left with B, C.
Well, spell that out for me. I can.
A was
connect.
the, so the A was the aggravated battery that the court found didn't apply.
Great bodily harm involving
With
great bodily
bodily harm. And then whatever the last letter was is the one where it talks about specifically intended child abuse, intentional child abuse. So those
Which
two,
encompasses, by definition, great bodily harm.
it does.
Yeah.
So those two are gone. But what is left, which was torture, malicious, and unlawful caging, there is nowhere in the instruction that it carves out any exception for the parental affirmative defense for any of those subparts.
Well, okay, so the Radford decision, let me find out. I thought that was dealt in the Radford decision, and what I thought that it said is that any exceptions must be in the statute itself. Let me see if I can find that for a moment. Okay, so they adopt the language, I think, of the previous decision in Radford, where they were citing I made a note of that, so I can't find it right off. Let me just bear with me just for another second. Okay, so the only other thing I would cite in the Radford decision is the Supreme Court's admonition toward the end, where it says, however, we conclude that this difficult task is principally a legislative function better left to the legislature. As the Fourth District has previously observed, cases like this should stand as a warning to those, parents and others alike, who quickly turn to corporal punishment as a solution to child discipline problems. It is apparent that there is a serious risk of going too far every time physical punishment is administered. So that brings me back to where I think I started with this, is that because the corporal punishment is no longer a part of what the jury will hear on the aggravated battery, my conclusion still is that it's not a defense as the count currently stands. But that being said, I understand the state's position, and if the state is telling me that you don't want to take a risk that I'm wrong on this issue, and that you would rather the parental affirmative defense be presented to the jury, I'm fine with that. At some point, there's going to be a judge who says that, no, I'm going to stick to my guns, and this is going to the way it's going to be, and it'll get tested on appeal again. But I'm not of that ilk at this stage, because the law, to be candid, is not crystal clear on which direction to go here.
Yes, Your Honor, that's correct. We agree with Your Honor, but out of abundance of caution, we're just going to leave it in there.
All right, so that takes away the issue for you, right, Mr. Wahid? So there's no issue then.
But we're still going
No
to
issue
argue
for me.
that, it was not reasonable.
I understand, right, and the permissible limits are an issue with not only the aggravated child abuse count, but it will be an argument with respect to the lesser as well. Okay, so was what I wanted to let you know that I had gleaned from my review of the decision and the instruction yesterday. I've looked at the instructions that were presented, and everything looks fine to me. Are there any issues that I need to address with respect to the currently presented draft of the instructions?
The only thing was, I didn't know if defense wanted 3.9B, the defendant's statement. The only statements that we have from the defendant are the ones from the video. I don't think that it applies in this case, but I just left it in for them to let me know whether or not.
3.9B,
Yes.
so what's your position on that? Well,
I don't think it applies, actually. I think that's when there's a statement usually to,
Right, usually a statement made to an officer or something like that, or body cam. So 3.9B will come out. So just remove that from, and before we finalize this, we'll go back through each and every one to make sure we have the proper order. So 3.9 comes out. Any others that should be excluded, and then I'll go through the order in which I'll read the instructions to the jury once we reconvene.
That was it, Your Honor.
Okay, so let me go through the instructions. I'd like everyone to follow with me in the order that I'm going to read these. The jury will be provided with a copy of the instructions in the box, and they will be permitted to take the copy that we give them back to the jury room for deliberations. The only thing they will not be able to take back with them as part of the package is the verdict form. We only ever allow one verdict form to go back to the jury room. Okay, so the preliminary instructions, I will not read them again, but they will be part of the packet. 2.1. The same for 2.1A, note taking, I will not read that again, but it will be part of the packet. And then introduction to final instructions is where I'll start with the.
For the jury's copy, I did start at 3.1.
That's fine. Yeah, that's fine. So the 2.1 and 2.1A do not have to be a part or part of the jury copy package. Okay, so we'll start at 3.1 as far as what I'll read, then 3.2. So as we go through each one, let me hear yay or nay from both sides so I have on the record both sides consent. All right, 3.1 everybody's good with, correct?
Thank you, Evangeline
All
Light,
right,
for gifting 5
3.2,
memberships. Thank
statement
you.
of the charge. Everybody's good with that one, right?
Yes.
yes.
All right. Then we'll go into 16.1, which is the aggravated child abuse instruction. And I will just note for the record that this instruction, in my view, is drafted against the affirmative defense beyond reasonable doubt.
And Your Honor, I don't know if your copy had the mental injury, but I had spoken to defense. I took the mental injury out of it.
I think that does need to come out because that's not part of what's left. So
Yes.
you're in agreement with that?
I'm in agreement with that.
All right, so the mental injury paragraph comes out. So after the maliciously paragraph, we will then move to the paragraph, it is not a crime. So that will, and then I'll ask that you print me one final set of the changes. Okay. All right, and then we'll go to 9.2, false imprisonment. Everybody good with that?
Yes.
All right. And then 16.6, neglect of a child. Everybody good with that?
Yes.
Yes.
All right, so that will then mean we move on to 3.4 where we talk about any lessers. And so the 3.4 instruction will advise the jury that the lesser for aggravated child abuse is child abuse. Everybody good with that? All right. Defense, good?
Yes, Judge.
Hold on, I don't want to let these get away. P. Cooper, happy anniversary for 3 whole months. I'm so glad you're here. And thank you, Regina Crawford, for gifting a membership. We can now show the gifted memberships on StreamYard. Hallelujah.
Okay. All right, and then that'll take us to reading the lesser for count 1 of instruction 16.3 for child abuse. And that includes the same burden on the state to disprove the affirmative defense beyond and to the exclusion of a reasonable doubt. And mental injury remains in this one?
Yes.
Okay, all right, good enough. All right, 16.3 is good. All right, 3.58, principles, everybody good with that?
Yes.
Yes, Judge.
Okay, and then we move into the standard of 3.7, plea of not guilty, reasonable doubt, and burden of proof. Everybody fine with that, I presume, correct?
Yes.
Yes.
All right, and then weighing the evidence. The only issue I ever have with this is, do we need all of paragraphs 1 through 7? Have you've already pared this down somewhat, right?
Yes, Your Honor.
All right, are you good with 3.9, Ms. Waheed?
Yes, Judge.
All right, and state is good with this since you presented it. Okay. That takes us to 3.9A, defendant not testifying. Is that going to be the decision that's ultimately going to be made? I'll do the colloquy. All right, so when I get to that, so that means it will be reading 3.9A and to the jury. After that, we go to instruction 3.10, rules for deliberation. I assume everybody's fine with that. That's standard.
Yes.
Yes.
All right, and then 3.11, cautionary instructions, again, standard. I assume everybody consents to that.
Yes.
Yes.
All right, and then finally, 3.12, the standard instruction on the verdict. Everybody fine with that, correct?
Yes.
Yes.
All right, and then that takes us to the verdict form. I've looked at the verdict form. I don't see any issue that jumped out at me, so I assume everybody is fine with the verdict form, correct?
So Judge, the only thing with the verdict form is I do think that there should be, underneath aggravated child abuse, we should have a slot for whether they find it's torturous.
Why would that special finding need to be made? Is it for any purpose on sentencing or any other aspect? Because normally I would not do it unless there is a specific need for a specific finding that drives the sentencing decision to be made by the court.
Well, we believe it goes to the unanimity issue, right? Which is that they unanimously found that, for example, that it was child abuse due to unlawful education, where they might not be in agreement on that. They might not agree that it's unlawful.
What case do you have to rely on that unanimity is required as to the reason for the finding of guilty on any particular charge?
It's not so much a case, Judge, it goes to the idea of the jury coming to unanimity.
I want to.
But isn't the prevailing case law that if there are alternative means for finding guilt on a particular count, that case law, as I understand it, is that there doesn't have to be a unanimous agreement on the specific avenues of which you get to an adjudication of guilt, or excuse me, a finding of guilt, but that there has to be unanimity on the finding of guilt at the top level, that there doesn't have to be unanimity on the way you get to that. Do you agree or disagree with that?
I've definitely seen such cases like that.
Yeah. All right. So I'm going to deny the request to have any breakdown of additional findings. Well, I assume the state would be opposing that. I'm making I just don't think it's supported by the case law. So, any other issues with respect to the finding or the form of the verdict form? Mr. Wahi? All right. So then I'll go over the verdict form in detail. And then lastly, and I typically, in my court, the not guilty is the last one. I have them address the level of guilt based on the highest charge going down to a finding of not guilty. And I can assure you that has never been a problem in my courts with juries reaching a finding of not guilty if they think a defendant's not guilty. It happens all the time. So I think I'm fine with the order of the presentation of the consideration of the issues for the jury. Then that takes us to 3.12A, single defendant. That's a standard. I'm assuming no one has any issue with that. All right.
No.
And then lastly, 2.4, evidence of other crimes, wrongs, or acts. I assume this is something the defendant probably requested, right?
No. Yes.
Yeah.
Yeah, it has to be read in the final instruction, Your
All
Honor.
right. All right. Okay. So that's fine. And then we'll go into 2.7. And after that point, we'll 2.7 is fine for both sides. Again, it's a standard.
Yes.
All right. And then we'll move into closing arguments. And then once the closing arguments are completed, I'll then read the final instruction of 3.13, submitting the case to the jury.
Yes.
All right. So that's the order of them. If you can print me out a final reading set, Ms. Black, that comports with what we've done here. And then 1.1 was part of the original instructions. That doesn't need to be part of the package anymore. So just from 3.1 to where I read at the end, that'll be my package for reading to the jurors. Okay. So that takes care of any issues regarding the jury instructions. I think now would be appropriate to address the issue of the defendant testifying or not, and the court doing the necessary colloquy on that. All right. So, Ms. Murad, I know we talked about it already in the context of the jury instructions. This is a more formal addressing of that issue. Has your client made a decision in this case as to whether he will testify in his own behalf or not?
He has made a decision, Your Honor.
And what is that decision?
He will not be testifying.
Okay, so let's hand the mic to Mr. Ferriter. Mr. Ferriter, if you could start off by, you can be seated if you like, sir. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down, sir. Go ahead and state your name and date of birth, please.
Tim Ferriter, 4/17/75.
All right, and you read, write, and understand English, sir?
I do.
And what's your highest level of education?
College degree.
All right, are you under the influence of any drugs, alcohol, or other medications this morning?
I'm not.
Have you ever been treated for any mental or emotional condition?
I have not.
All right, and just to give you the context of why I'm conducting this colloquy, as you've heard, your attorneys advised me that you've made a decision whether to testify or not. And so, as I mentioned yesterday, I need to make sure that that decision is being made by you knowingly and intelligently, freely and voluntarily. So that's where these questions are intended to go to put me in a position where I can make a factual finding on those items. You understand all that, sir?
I do.
All right, and you're represented by your attorneys, Ms. Murad and Mr. Wahid in this matter?
Yes, sir.
And are you satisfied with their services?
I am.
All right, and have they done everything that you've asked them to do regarding the presentation of your trial and consideration of whether for you to testify on your own behalf or not?
They have.
All right, and have you had a full opportunity to discuss with your attorneys the pros and the cons and the risk and the consequences of testifying versus not testifying in this matter?
I have.
All right, and have they fully advised you of all those risks and consequences as far as you're aware of?
They have.
And have they been able to answer all of your questions regarding the various pros and cons, risk and consequences of testifying or not?
They have.
All right. Has anybody, including your attorneys, made any promises, threats, or tried to force you into a decision this morning that would be against your will?
No.
All right, so the reason I ask that is, and you've heard some of this from me before, there are basically three things that a defendant absolutely controls in a criminal proceeding. And what I mean by that is, although you can receive the advice and counsel of your attorneys, ultimately, I don't look to your attorneys to tell me what the decision is. I look to you to tell me what your decision is, because your decision is what governs. Those three things are: one, whether to plead guilty or not guilty; two, whether to go to trial or not go to trial; and three, whether once you are in trial, whether to testify in your own behalf or not. Obviously, you've already made and gone past two of those decision points, continuing with your plea of not guilty and also continuing with the decision to have a trial. So now we're at that precipice where I told you we would arrive at one day, once the trial were to begin, as to whether you should make a decision to testify on your own behalf or not. There are certain consequences that I do want you to be aware of if you were to testify on your own behalf. And one of those is that you will be subject to cross-examination by the defense. The only way the defense ever can have an opportunity to cross-examine you in this case is if you take that stand there and you subject yourself to direct examination by your attorneys. Then that opens you up to cross-examination by the state. You understand that?
I do.
Right. Another area is that do you have any felony convictions or misdemeanor convictions involving truth or dishonesty? They could also bring that out. Now, does the state have anything like that that it would potentially bring out against Mr. Ferriter if he were to testify? All right, so that's not a real worry. It's a worry for a lot of defendants that come before me, but it's not a worry in your case because you have no history. So the real risk is that you're opening up yourself to cross-examination by the state. Based on the colloquy that I've given you thus far, do you have any questions of the state, of the court, about anything I've discussed or explained to you this morning? All right, after this colloquy, do you feel like you need to take any additional time to speak with your attorneys regarding the decision that I'm going to ask you to tell me in just a moment?
No, thank you.
All right, have you made a decision in this case whether to testify on your own behalf?
I have.
All right, and what is that decision, Mr. Ferriter?
To not testify.
All right. Based on the court's colloquy of Mr. Ferriter, sir, I find that you're making the decision knowingly and intelligently after having had the opportunity to receive the advice and counsel of your attorney. I also find that I've explained to you the potential risk and consequences of testifying in your own behalf on the stand, including the fact that you would subject yourself to cross-examination. Based on all that, I find that you're also entering into this decision with an appreciation of those risks and consequences, and that you understand the same, and that your decision is being made freely and voluntarily. So I accept your decision not to testify as having been knowingly and intelligently, freely and voluntarily made by you. So that concludes the colloquy on this matter. Sir, you may give your attorney back to Mike, and thank you, sir. All right, we are set to start back. Ms. Murad, you're standing. Anything I need to address? Oh, okay. All right, so we're set to start back with, so when we come back at 1 o'clock, the defense will rest. And at that point, I will begin the closing instructions. So we'll immediately move in to closing arguments in the same time limits and deadlines, and time warnings will apply as we put on the record yesterday. Anything else I need to address before we reconvene at 1 o'clock?
No, just, are you gonna instruct or do we start right away? Do you instruct before or after
Before or after what?
closings?
No, I instruct before, because the attorneys, whether you're the state or the defense, spend a lot of time arguing the law in your closing. So I think it's most beneficial to have the jury be advised of what the law is before they hear your closing arguments.
Fine, just
Yeah,
wondering.
that's been my normal practice. I assume everybody's in agreement with that, right?
Yeah, the state has no issue.
All right. Okay, well, that's the way we'll do it. Anything else I need to address? Yeah, thank you for raising that so that we can address that now and not delay the proceedings any further. So go ahead, Mr. Wahid. So what I'll do is have you make the motion now and make your argument, but I still want you to make the motion on the record after you've rested, and I'll just say same ruling as made previously, if that's my ruling.
Understood.
Whatever I rule at sidebar or in open court now, that will be my ruling, and that'll be the ruling I'll adopt when you renew the motion.
Understood.
So go ahead.
So first, we're going to renew all of our previous motions and objections that we've made throughout this trial, orally or in writing. And in terms of my second judgment of acquittal argument, it essentially is the same as the first judgment of acquittal argument. The difference at this point would be that the court's now heard from a few extra witnesses, and I think those witnesses, especially Dr. Rappa, give enough for us to make I think, an educated judgment that no reasonable juror could find against Mr. Ferriter. The essential element here that the jury is going to be deciding upon is the criminal intent. The actions are mostly in agreement by both parties. There's a few here and there. It is really a question of, was this being done for a purely torturous purpose, for a purpose of being simply malicious, or for a purpose of just for no reason, unlawfully, in other words, caging. And I do think that we heard from Dr. Rappa, who talked about the history of the child, the different diagnoses, the interaction of the child in terms of the behavior elements, and how that informed the parents in terms of what they then had to do in response to each of those moments. And while we've all been here for only a week, I'm sure it feels like a month, but for a week on this case, they've lived with it for somewhere in the range of somewhere between 8 and 10 years at least of Ronan's life. So from that perspective, their actions, and we heard it on the video admitted by the state, where Mr. Ferriter said that he was not giving up on this child, that what he was doing here was to try and right the ship, that Ronan kept conducting himself in a manner that was going to continue to get him in trouble. And this, while started when he was young, now he's 14 and it's still going on. Where is this going? So the actions taken, and that's the key part of the statute, the intent of those actions was not for a torturous, malicious, or unlawful purpose. It was for a justified, lawful parental purpose. And that's what I believe the jury instructions clearly say, and I think that's the decision upon which the court should grant the judgment of acquittal.
All right, so let me ask a couple questions for you. Do you agree that the standard, again, is at this stage, is that no reasonable jury could conclude that the defendant is guilty of aggravated child abuse? That has to be the standard that I look at.
Yes.
All right, so how do you deal with the fact that, and I acknowledge your representation of the testimony of Dr. Rappa with respect to the maliciousness aspect, but in order to get to where you want me to be, then I would have to totally ignore the testimony of Dr. Myers. And so my concern is I have conflicting expert opinions here that ultimately the law tells me I'm not the one to decide between those two. It's the jury, and that they have to decide because there is evidence that both sides have submitted on that issue. And it strikes me as just part and parcel of what the system is all about, that when you have disputed issues like this, the judge doesn't decide it. The judge lets the jury decide it.
I think it's worth the court noting that the opinions on maliciousness by psychologists and psychiatrists are ultimately lay opinions. They're not in the DSM-5. These are opinions that these are their own opinions and observations, but those are not medical diagnoses.
Yeah, and I don't know that I totally disagree with that position, but I don't know that it helps your position on the JOA, because then you have to look at the conduct, you have to look at the circumstances, and those are things that really fall into the penumbra of what a jury would look at in making its own determination. So I don't know that that helps you. I kind of agree with you to some extent that those may be closer to lay opinions than expert opinions, but they've been rendered in this case as expert opinions. But if the jury disregards the expert's opinions, as they are free to do, then they still have to look at the facts and circumstances and make their own conclusion and arrive at their own determination as to whether it was malicious. You agree with that basic precept?
So the part about the experts, I don't agree, in that there was a relevant testimony from them that does help inform the jury, and both experts agreed that the child suffered, there's evidence the child suffered from RAD, reactive attachment disorder, and both agreed that that would have been something that would have happened in those first 17 months or so of his life before he was adopted by the Ferriters. So regardless, both would agree that his behavior is very likely a result of the reactive attachment disorder, and that the reactive attachment disorder was present when he was adopted by the Ferriters. So they didn't create that. So it is a situation where they are now dealing with his conduct completely improperly, but they are dealing with it as they believe parents.
But your own expert testified that the conduct, the response worsened the RAD, the reactive attachment disorder.
100%, but that isn't the question before the jury. The question is, was the intent to make it worse, or was that their attempt at parenting?
Okay. All right. Thank you, Mr. White. Anything else?
No, Judge.
All right. Who's going to argue for the state? Ms. Black?
Yes, Your Honor. I would just make the same argument that you had made before on the first JOA. Based on the evidence that has come out, this case should be submitted to the jury, and they're the ones to make the decision as to whether he's guilty or not.
Okay. All right. Court's going to deny the second motion for JOA, pretty much for the same reasons that I denied the first one, and that is that I think that enough factual circumstances and enough disputed testimony has been presented that the court cannot decide this is a matter of law, and that it will have to be decided on the facts and the law by the jury. So that's the court's ruling on that. So what I would ask, Mr. White, when you and Ms. Murad rest, you'll make your motion, stand up, and then I'll say the ruling on the record previously stated applies, and then we'll go into my reading of the closing instructions. Okay? All right, anything else that I need to address? All right. Seeing no responses, I'll give you folks about a 12-minute break. We'll start back up at 1 o'clock sharp. Mark, we have all the jurors here? Okay.
Bring the jury.
Some evidence in yesterday, and I'm just getting the date time stamps on those, and then I would have to evidence 16, there were 3.
Do we need to go over what has been accepted and received by the court just as a matter of caution for everybody? I mean, I'm happy to do that.
Yes, Your Honor, just for the record, I know we have some about this defense's large exhibit. I did let the defense know that in addition to the sustained objections yesterday that Your Honor ruled upon, there was 2 additional videos that I objected to, and it's my understanding that they're going to modify the exhibit.
It was that 18, exhibit
Yeah,
18?
and
All right.
and replace that exhibit. And then by agreement, there were a couple dates that we wanted to put on the record. There was one date that the state wants to put on the record, and then a couple that the defense wants to put.
Okay, so I have states exhibits 1 through 22 in evidence. I won't state whether they're over objection, without objection, or whatever, but 1 through 22. Does that, Madam Clerk? All right, so for the defense, and just make sure I'm correct here, Madam Clerk, I have exhibits 2, 4, 7, 15, 16, 17, and 18 in evidence. And as for ID only, I have 1, 3, 5, 6, 8, 9, 10, 11, 12, 13, and 14. Does that comport with yours, Madam Clerk? All right, Mr. Wyatt or Ms. Murad, is that any issues with that? Okay, all right, so that takes care of that. All right, we'll be in recess until 1 o'clock, and then we'll start with the instructions. Ms. Black, before I step off, these are the new reprinted ones?
Yes.
All right, I'll look at them just to make sure they are where they need to be. Okay, thank you.
Judge, if we can just discuss defense exhibit number 17, I never received that. I think defense is making changes to it.
Use the microphone.
We don't have a working microphone.
Um,
They were getting new batteries.
Getting new batteries.
Judge, we, based on the state's objections, it was only over 4 videos. We agreed to remove them. Because it's a 14-hour video, it takes a minute to remove them and then re-render it. So we will submit that into evidence, but it might have to be after closings.
Okay, all right. Fair enough. Does that answer your question, Dana?
Your Honor.
Okay, all right, court will be in recess until 1 o'clock.
I want to. So, all right. So they said last week that they were going to do court today from 12 to 5. And then yesterday they said that they were going to start at 1. So I thought they changed it to 1, but apparently they are starting at 1, but they were keeping the 12 o'clock for them to come in to talk about the jury instruction stuff. So here we are. We are here. I missed y'all yesterday. We had a nice time chatting it up. We rated Ikadmel's chat because he is another streamer who is showing this trial live. I knew we wouldn't have time to catch up if we didn't watch it. So I tried to argue with our fiber internet people all day yesterday. They are still working on whatever it is. I guess there's a switch or something that I don't know. I don't know any. I'm a plug it, unplug it and blow on it like a Nintendo thing and plug it back in. That's all. I know that I'm a technology goddess, but that's the extent of my, you remember those? You take out your, and put it back in, back to Mario, bam. It's still, as they're working on it, it's much better today, but every once in a while, it's like, I don't know if I feel like working. All right, I'm back. So that's kind of how it's doing. So we'll see how it goes. Fingers crossed. So I am glad to be back. I missed y'all. It was fun rating his chat. It was fun to just be a chatter, just to go in and cause trouble and get timed out in somebody else's chat. I'm just joking. We were on our best behavior. But as lovely as it was to just go chat with a bunch of other people and to not have to run all the behind the scenes stuff. That part was a nice little break, but I am glad to be back with y'all. Also, when he had trolls, I'm like trying to delete their comments, and then I realized I have no power, and I'm like, well, this blows. So, you know, I like being where I have the power. The power. Lucy is feeling better today. I am not. Where is she? Oh, she's laying over here. I don't have Lucy Cam on only because they're still working on the fiber stuff, and I want to try to keep the bandwidth. Like, I don't want to push my luck with the bandwidth stuff. So I'm like, I feel like 80s Music Man. Like, I'm kind of like tiptoeing around, hoping to not get noticed, you know, like if bandwidth realizes I'm here, they might kick my butt on out of here. So we're going to not push it until I get the call from them that they're done. I have been instructed, don't call them, they'll call me. So there's that. But you know, yeah, we'll see. All right. So I am seeing all of the messages about Turtle Boy. So let me go ahead and address it. Yes, he was arrested this morning. I actually I was recording episode 4 last night of the podcast, and up until I think I finished about 6 o'clock this morning and finally went to sleep. And I had taken a break from recording and popped into his live last night. He did a live. I didn't catch the whole thing, but I popped in and I saw he gave the podcast another shout out, which is great. But I went to bed about 6 o'clock this morning, and then I woke up about 9. So we're running on 3 hours here. But I woke up at 9 and my inbox was like flooded on every single platform that he had been arrested. The charges say witness / because it's like a blanket charge or whatever. It says witness / juror / police intimidation, I think is what it is. So and he's got multiple counts. So he is but let me show you this. This is actually kind of funny. You know, he has been, I think in the episode 1, I called Turtle Boy the loudest guy in the room. Because he has been, see my little StreamYard, like my little bandwidth thing is like, every once in a while it's like, I don't know if we can do this. All right, I'm good. Don't know why. So this is what he's wearing as they're arresting him. He's wearing his Free Karen Reed hoodie, which I thought was kind of funny actually. But if y'all have, my face is peeling where I got sunburnt. Remember how I was sunburnt Sunday on whatever episode that was. I need to go get some lotion in a minute. Anyway, so he is a blogger / journalist that has been one of the loudest supporters of Karen Reed. He does a lot of investigating into, especially like a lot of the connections to people and a lot of the behind the scenes stuff. I have seen some of his stuff, but here's my thing. I haven't watched everything of his because I don't want, because his viewpoint is very clear. And I don't want my viewpoint to be influenced based on what somebody else is saying. So I started my investigation, you know, seeing some of his stuff about like who's, you know, who has personal connections behind the scenes and stuff like that. Like some of that stuff I've, you know, watched a lot of, but as far as like some of the investigation stuff, I didn't want to be influenced. So I did my own, so that I can come to my own conclusions without outside influence. So, but I have seen clips. I do know that like he has been very vocal about, the Alberts and the McCabe's, which if y'all listen to the podcast, you know what I'm talking about. If you don't, then where have you been? Go listen to 13-0 podcast, the conspiracy in Canton. But it has been months of, he's very vocal about, when he sees corruption, he wants to call it out. He is, like, what are y'all hiding? But he is, his style is very different than mine. He is very abrasive, and nothing wrong, with everybody having different styles. But he is very abrasive, and he has been very vocal about his dislike for the McCabe's and the Alberts. But it's I'll say this. He has a huge following, and he knows what he's doing. He is pressing their buttons on purpose. He's getting more attention on this case. So like him or love him or hate him or neutral or whatever, he's doing exactly what he set out to do, which is get more attention on this case. So he is, he's been very, very instrumental in all this. So it's crazy, but and he's been a big supporter of me, and I do appreciate that. He has, shouted out the podcast on his Twitter and on his lives, and he's gone on other people's lives and shouted it out. Like, he's given a lot of great compliments to the investigation and the work that I've done on it. And, I do appreciate that. He and I have very different styles, but you can't help but watch him. And he gets a lot of attention on it. So, but he's got, when I looked this morning before I started, I think it was 6 charges, I guess, for the 6 witnesses, but I'll have to pull more information on it later. But yeah, that's my inbox was flooded, and my Twitter and my, everything. So, but he, somebody said he called it, like he predicted it or whatever. So not surprised. He goes to because one of the Alberts is a select board member, and he went to the select board meeting and held up a sign saying Chris Albert killed a man. Which that'll be in a whole nother podcast. Like, that'll be in another episode. It's true. It's from years ago. It's a whole big thing. Anyway, when I tell y'all that this case is so complicated, when I started on it and I decided to do the podcast on it, I had no clue what I was getting myself into. No clue. And that's why I only sleep 3 hours a night now. That's why I only sleep 3 hours a night. But crazy. But yeah, Turtle Boy, aka Aiden Kearney, is arrested with his Free Karen Reed hoodie on. But look, he's doing exactly what his goal is, which is getting attention on this. So it is interesting. Sugar Bacon, you've been up for 56 hours? Dang. That's nuts. Let's see. Mighty Heidi says, I sent a text to RA a month ago about the Karen Reed case. I knew it was going to be crazy. Yeah. I started the podcast a little over a month ago. The first episode came out a little over a month ago. I actually started on it way before that. Man, is it because there's so much on it. So much. But it is, it's nuts. And oh my, it's just, there's every time you think you have everything, then there's more. And we don't even have all the information yet. Like, we don't have all of the grand jury testimony, and we don't have, all of the phone records, and there's so many connections. We're going to watch all of the hearings, all of the pretrial hearings. We're going to do that as we go through the podcast stuff. And we get a little bit further into it. We're going to watch all of the pretrial hearings. I don't want to watch them yet because episode 4 is out now. We're still kind of because this is so complicated, we're still kind of in a lot of the introductory phase of things. But we're going to watch all of the pretrial hearings and stuff. And then, trial is set for March. So we are going to be, we're going to be right there. I'm going to be streaming it. We're going to be ready for it. This is so complicated. So we're starting now. Well, actually, we started a little over a month ago, and we are going to, we're going to, 13 jurors will know more than anybody else on the internet. Guarantee it. So interesting. I did not listen to the Daybell hearing. I have it saved to my stuff to listen to. I did not listen to it because I was focusing on the podcast. I need water. I'll be right back. Talk amongst yourselves. Everybody you just wait right there. Okay. I'm back. Has everybody behaved? Thank you very much. Thank you very much. Amy Bo, yeah, the jury's coming in now. They started a little bit early just to argue a few points on the I'm so tired. I can't form sentences on the jury instructions. Hold on, I think Turtle Boy's hearing is happening right now. Yeah, it is.
Providing here is that we don't believe that because of his record or because of his commitments that he would be in danger of flight or creating a problem in terms of needing bail. As far as the conditions go, my client states that he is a news person who is using his First Amendment rights to cover a story. Now, I know that he is doing it through YouTube, through social network, but there are a lot of people.
Offenses taken place on various dates. One count of picketing a court judge or juror. These offenses taken place on June 13th, 2023 in the town of Camden. Docket 23 CR 1156, being charged with one count of intimidation of a witness, juror, police court official. These offenses taken place on various dates in the town of Camden. Docket 23 CR 1157, being charged with one count of conspiracy. These offenses taken place September 25th, 2023 in the town of Avon. Docket 23 CR 1158, being charged with one count of intimidation of a witness, juror, police court official. These offenses taken place on various dates. One count of picketing court, judge, or juror. That offense taken place on June 6, 2023 in the town of Canton. Docket 23 CR 1159, being charged with one count of intimidation of a witness, juror, police court official. Those offenses taken place on various dates. One count of picketing a court, judge, or juror. That offense taken place on June 6, 2023 in the town of Canton.
Thank you. Good afternoon, sir. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violate a release condition during the pendency of any one of these cases, one or more of these cases, you could be held on any one or more in the House of Correction. for
That's
up to
Turtlewood.
90 days without bail. Counsel, does the gentleman qualify? Yes, private counsel. Okay. Mr. Reynolds, will you
Yes,
stand
Your
up for today
Yes.
and for the Commonwealth?
Good morning, Your Honor. Attorney Kenneth Mello, Special Prosecutor for the Commonwealth. With me is Attorney Robert Novak, also Special Prosecutor of the office.
All right, good afternoon, both of you. Good afternoon, Mr. Reynolds. Mr. Mello, do you have any requests for the court?
I do, Your Honor. I have a number of requests for conditions of release. Where Commonwealth is requesting cash bail in the amount of $1,000, GPS monitoring,
GPS monitor.
stay away from all witnesses 100 yards, and that would be with the exception of court appearances that the defendant is required to attend if other witnesses are present. We're asking for a 100-yard stay away from the witnesses' homes, businesses, places of employment, and schools. We're asking for no contact with witnesses by phone, text, email, or otherwise, either directly or indirectly. We're asking
Rise, floor is back in session.
Spend
Judge Howard Coates
through
presiding.
his blogs and internet
well,
use.
They're about to
and
do
not,
jury instructions.
Encourage a court order.
I wanna
to not
watch
encourage any of
This
his
for a minute,
blog
then we'll listen to jury
followers
instructions.
to call
This
or
won't last
visit or otherwise intimidate or harass witnesses. As Your Honor may be aware, this defendant has a blog with a rather large following, and that will get to the root of the case itself, but it appears that in the past he has
You are muted. Please, you are unmuted.
appears in the past he's encouraged his followers to take various actions with respect to witnesses in this matter. We're asking that there be no harassment of witnesses or their families, no intimidation of witnesses or their family members. We're asking that he not on his blogs or otherwise encourage his blog followers to photograph witnesses, their families, their homes, etc. As Your Honor will hear from the evidence presented by the Commonwealth's argument, the defendant has shown up at sports games attended or that were being engaged in by children of witnesses, and has made scenes there using loudspeakers, etc. We're asking that he be precluded or prohibited from attending those sports games, school or otherwise, to harass witnesses. That there be no mentioning by names or other forms of identification of the witnesses on his blogs, Twitter, YouTube, etc. When I say witnesses, I'm also talking about the victims in this case, Your Honor. The victims in this case all being witnesses in another matter.
He doesn't.
They will address.
Wow.
Certainly, this would not preclude the defendant from talking about other cases, but not with respect to discussing the witnesses and their family members, etc. We're asking that he have a stay-away order from D&E Pizza, and that he be precluded from encouraging his blog followers from harassing and intimidating that business, that he not contact Witnesses, family members, schools, sports teams, coaches, etc. He has done that in the past, Your Honor. That he not photograph or video witnesses at home or work, and that also goes to taping, Judge. And he not contact the place of work of the witnesses or victims. And I have a large number of facts I would like to make the court aware of. I apologize for the time it's going to take. There are 9 complaints before Your Honor. Some of these facts apply to all. If I could just read that section to the court once or recite those facts and then deal with them individually. Thank you, Judge. Your Honor, on the morning of January 20th, 2022, a gentleman by the name of John O'Keefe was found unresponsive on the front lawn of 34 Fairview Drive in Canton, Massachusetts. He was transported to Good Samaritan Hospital where he was pronounced deceased. The Office of the Chief Medical Examiner determined the cause of death to be blunt force to the head and hypothermia. Evidence was presented to the Norfolk County Grand Jury that indicated on the night of January 28th, 2022, Reed and O'Keefe were at 2 Canton restaurants, C.F. McCarthy's and the Waterfall, where they met friends after, and this is Karen Reed. After the Waterfall closed shortly after midnight, Karen Reed and Mr. O'Keefe were invited to 34 Fairview Drive, Road in Canton. Witnesses stated Reed and O'Keefe did not enter 34 Fairview Road. The Norfolk Grand Jury indicted Karen Reed on second-degree murder, motor vehicle manslaughter while operating under the influence of alcohol and leaving the scene of a motor vehicle crash causing death. The indictment alleges that Karen Reed struck O'Keefe with a motor vehicle and left the scene, and the case is currently pending in Norfolk Superior Court as docket number 2282 CR 117. The lead investigator.
Just for the record, there are many people attending this hearing via Zoom. We're doing the best we can to keep them all muted. When you hear some random utteration like you just did, that's from someone who has not yet been muted.
Thank you, Judge. The lead investigator for the investigation I've just
The boy in the box trial, they're about to go over jury instructions. So we're not missing anything exciting. We'll catch up in just a minute. This is the hearing that's going on right now for Turtle Boy, who is involved in exposing the Karen Reed case that I've been covering on the podcast. So we're not missing anything exciting. It's just jury instructions.
Described as Trooper Michael Proctor of Massachusetts State Police, assigned to the Norfolk State Police Detective Unit. Trooper Proctor testified before the grand jury and continues to conduct investigative work on the case. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to the investigation, but a family member, as mentioned in Chapter 268, Section 13B of the General Laws. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. These civilian witnesses were present with O'Keefe and Karen Reed in the hours leading up to O'Keefe's death and his discovery on January 29th, 2022. The witnesses include the following: Matthew McCabe, who was interviewed by investigators. Matthew was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and observed an SUV believed to be that of Karen Reed's in the front of 34 Fairview Road and he testified at the grand jury. Jennifer McCabe was interviewed by investigators. Jennifer was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV believed to be Reed's in front of 34 Fairview Road, and was with Reed when O'Keefe was found unresponsive and testified at the grand jury. Brian Albert, interviewed by investigators. Brian was with O'Keefe and Reed at the Waterfall restaurant and the homeowner of 34 Fairview Road and testified at the grand jury. Julie Albert, the wife of Christopher Albert, was interviewed by investigators. Julie was with O'Keefe and Reed at the Waterfall Restaurant before O'Keefe's death, and she testified at the grand jury. Chris Albert, husband of Julie, was first interviewed by investigators on February 10th, 2022. Chris was with O'Keefe and Reed at the Waterfall Restaurant before O'Keefe's death and testified before the grand jury. Colin Albert was interviewed by investigators. He is the son of Chris and Julie Albert. And Juliana Nagel was interviewed by investigators. She was present at 34 Fairview Drive when people were arriving from the Waterfall Restaurant and observed an SUV believed to be that of Karen Reed parked in front of 34 Fairview Drive. In an April 2023 motion filed by Reed's defense attorneys, defendant's motion for order pursuant to Mass Rule of Criminal Procedure 17 directed to Brian Albert, Verizon, and AT&T, alleged police misconduct and a conspiracy among civilian witnesses to frame Reed for the death of O'Keefe. The motion calls Brian Albert a suspect and Jennifer McCabe a conspirator who took calculated steps to purge her phone of this inculpatory evidence. A local blogger, the defendant, Aidan Kearney, had adopted the defense's claims. Kearney runs a series of websites and social media accounts under the name of Turtleboy. The social media accounts include TV Daily News, X, formerly Twitter, with 33,800 followers as of last count. Aidan Kearney at Dr. Turtleboy, X, formerly Twitter, with 44,800 followers. Turtleboy, Facebook with 27,000 followers, and Turtleboy Live on YouTube with 41,000 subscribers. He refers to his followers as Turtle Riders. Now, it should be noted that the defendant on many of his sites, his websites or blogs, if you will, has a pay section where he's requesting contributions from the public to support his work, if you will. And some indications are that it's been estimated on the internet that he has raised in excess of $5 million doing so. So this is apparently a business of his that he's engaged in. The beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses and members of their families and their friends. Kearney authors and publishes a blog on the website tvdailynews.com. The website has a series of articles entitled Canton Cover-Up. As of September 28, 2023, at least 164 articles have been posted to the website in this category regarding Karen Reed, and there have been additional articles since that date. Kearney posts weekly videos to YouTube where he has discussed Karen Reed and made statements regarding witnesses. Below are a small selection of the verbal statements made by Kearney in these videos that have been published to followers and are publicly available for viewing without being a subscriber or follower and have been archived by investigators. Episode 594, Turtleboy returns to Canton. This is a video posted shortly after Kearney visited homes of witnesses. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. These people think I'm fucking around. You haven't seen the last of me. Get used to it. Get used to it at the 119 mark. Episode 598. Waiting. Karen Reed defense files motion to recuse. This guy, meaning Chris Albert, had his head on the swivel looking for turtle riders. I got bad news for you, Chris. I got really bad news for you. They are literally everywhere. You guys should just stop going out in public. It's only going to get worse from here. I know where you all were today. You were in Agawam, weren't you? You guys were at some sort of Little League thing in Agawam. Alberts, McCabe's, all you people were there. Just know that there will be no life as normal is over. Life as normal, you had normal for a while there, from January 29th to about April 2023. You guys literally got away with murder. States that at the 8-minute mark. While discussing the video of Chris Albert being confronted outside of a Canton restaurant, we, Kearney and his audience, are getting to them. Chris Albert, meaning Chris Albert and other witnesses. When you act this way, that's like a green light for me, time to hit the gas. I got pictures of you. You can't leave the fucking country, Turtle Riders. We're gonna find you. They're gonna find you. You can't hide anymore. Your private life is officially over. You leave your house, you're gonna have your picture taken, so you need to get used to the new normal, your new normal. Turtle Riders are gonna take pictures of you, and they're gonna send it to me. You're famous. We need to accelerate it. They, the woman who recorded the video of Chris Albert confrontation, are doing a fantastic job with this. Stated that at the 24-minute mark. In episode 604, entitled Colin Albert Drops Out of School, Brian Higgins Flipping, is the end near. I said from the beginning, I don't want this to go to trial. That is this defendant's words himself. I don't want this to go to trial, referencing the Karen Reed case. On September 18, 2023, Kearney posted a blog entitled Canton Cover-Up, Part 142, Free Karen Reed. Billboard goes up on Route 1 outside Gillette Stadium in Foxborough. More to follow on his website. The topic of the blog post was about a billboard that read, Free Karen Reed, with a picture of Karen Reed. Kearney praised the organizers of the billboard. In the post, Kearney wrote, thank you to everyone who donated as well. Although millions of people know about the injustice that is happening in Norfolk County, I would bet that over half the population of Norfolk County has never heard of Karen Reed before. That will change because of this three-pronged billboard blitz. It's really time for people in Norfolk County to know about this story, because that is where the jury pool will be chosen from. Essentially, Judge, an admission that he's seeking to taint the jury pool in the case. On June 13th, 2023, Kearney broadcast a live YouTube video, episode 590, which is currently posted on his YouTube page. During the broadcast, Kearney displayed phone records of Jennifer McCabe from the day O'Keefe was killed. The records displayed names to the phone number, displayed names next to the phone number, which appeared to be the user of the other phone. These records had previously been an attachment to an unredacted defense motion filed in Commonwealth versus Reed. During the video broadcast, Kearney cold calls the phone numbers without names associated. In this process, he called the work cell phone of Trooper Proctor. Trooper Proctor stated the phone number that made the call was 413-262-69, and I'll omit the last two numbers, Judge. Kearney left the following voicemail. Hi, Trooper Proctor. This is award-winning journalist, Aidan Kearney calling. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before doing the investigation, that you were good friends with the Albert family? Why did you in your report say that you were introduced to Chris Albert on February 10th when you have known him for more than a decade prior to that? Why did you lie about that? About what time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And you know, I'm just wondering about all those things, and maybe you and I can meet for coffee. Boy, do I have a lot of questions for you. Where were you inside Fairview Drive that night, or that morning rather? Why did you stay there for 4.5 hours? And what did you guys talk about and do? Why are you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot to talk of catching up to do. I talk about you a lot. I feel like I know you pretty well at this point. I know which year you graduated from the academy. I know you were out in West Brookfield for a while. I know some people that you know, so give me a call back when you get this. Now that I have your number, and everybody watching also has your phone number, which again is 781, and omit the remainder of the number. So I'd like to know, she called you again, you called her at 12:49. We're going to get to that. So now I have your number. I'm going to plug you in and we'll talk soon. Essentially broadcasting the trooper's number to his turtle followers, if you will, seemingly with the intent to have them also harassed. As a result of the cell phone number being broadcasted, Trooper Proctor began to receive random and harassing text messages and voicemails. In the 12 hours following Kearney's calls, Trooper Proctor received approximately a dozen text messages, phone calls, and voicemails. The content of the calls and messages pertained the Trooper Proctor's alleged involvement in the conspiracy and called for his termination. Trooper Proctor had to change his work cell phone number to avoid the constant unwanted calls and messages. Michael Proctor is married to Elizabeth Proctor. Beginning in April 2023, Kearney wrote blog posts about Elizabeth Proctor. On May 9th, 2023, Kearney authored a post about Elizabeth. A video was attached to the post. The video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Kearney further writes, I can think of two people who deserve to lose their jobs over this alleged conspiracy about Karen Reed, though. Michael Proctor and Elizabeth Proctor. These two lowlifes think they're untouchable. They're nothing but bullies who terrorize people for years, but now they've met their match, meaning the defendant. In the post, Kearney states Elizabeth works as a human resource manager, and I'll omit the place of employment, and posts the main number for the company. The post then says, but you're probably not going to reach anyone that way, so feel free to leave a review on their wide open Facebook page or their Twitter account. On May 10th, 2023, Kearney broadcast a live YouTube video, episode 580, which is currently posted on his YouTube page. During broadcast, at the 1 minute, 6 second mark, Kearney talks about Elizabeth. He states he was going to call her. He repeated his cell phone on the broadcast, a cell phone number on the broadcast, as he was entering the number into a cell phone. Using the speakerphone option on a cell phone, Kearney broadcasted the phone call. The phone call went to voicemail. Elizabeth stated the call came from 413-262-69. I'll omit the last two. Kearney left the following message. Hi, Elizabeth. This is Aiden Kearney calling you back from Turtle Boy. We briefly spoke yesterday on the phone. I introduced myself to you and then you hung up on me. Or maybe that was a bad connection. But I just wanted to see how your day at work went today, if it went well. I noticed that your employer took down their social media pages within 5 minutes of the blog I published about your recent behavior. And I just wanted to see what is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's the part I don't understand, is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun, maybe it's not as fun. Do you like that? That's what I want to know. Do you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? And what's your scumbag husband up to now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Please give me a call back when you get this and we can chat some more. Bye, girl. Following the phone call at the 108 mark, Kearney accessed the social media accounts of the company that Elizabeth worked for and laughed as he stated the pages were taken down and stated the Turtle Boy effect. Oh God. Both Mike and Elizabeth Proctor stated they felt harassed by the acts of Kearney. On Monday, September 25th, 2023, at 6:26 p.m.,
Read, Karen, read.
Facebook account believed to be used by Kearney, which is Clarence Woods Emerson, is the name, posted the following message. Anyone in Canton want to take a couple of pictures for me? DM me, please. At 6:53 p.m., the Facebook post was edited with the phrase, update all set, thanks. On September 25th, 2023, at 8:04 p.m., an X account, formerly Twitter, associated with Kearney, posted this message and photograph. The post depicts the front of 6 Wentworth Road in Canton, home of Michael and Elizabeth Proctor. The white Jeep Wrangler in the photo belongs to Jennifer McCabe. And there are photographs that are appended to this report I'm reading from, Judge. The following day, Kearney broadcast a YouTube video, episode 617. At the 19-minute mark, Kearney stated that he ran the plates of the vehicle depicted in the photograph. Kearney showed photographs of 3 vehicles parked at the address. He showed photographs of each vehicle and stated the registered owners of the vehicles by name, Michael Proctor and Elizabeth Proctor. The term ran in regard to a motor vehicle registration is commonly used in law enforcement. The term means the information was queried through law enforcement database for the purpose of obtaining information. Kearney used the information in a blog entitled Kenton Cover Up Part 161. Jen McCabe was seen at the Proctor's house at 6 p.m. tonight, despite allegedly not knowing them personally. I would Parenthetically, state judge that it was later determined through an investigation by state police that a dispatcher in the local police department made contact with Kearney and unlawfully and illegally accessed the Registry of Motor Vehicles database to provide him with information he was not entitled to. Information maintained by the Registry of Motor Vehicles is accessible to law enforcement through the Criminal Justice Information Service. Authorized individuals have personalized access to the CJIS logins and accounts. Recertification standards, which include lessons and tests, continuously assert that CJIS users are trained to the standards and do not disseminate protected private information unless for a legitimate law enforcement purpose, as described in the Massachusetts Code of Regulations 803 CMR 7.09. On Tuesday, September 26, 2023, Lieutenant John Fanning of the Massachusetts State Police conducted a CJIS audit to determine if any CJIS user queried the following: Massachusetts registrations. I will omit the registrations at this point, Judge, but one is for Matthew McCabe's vehicle, who is Jennifer McCabe's husband. Another is for Michael Proctor's vehicle, another one for Elizabeth Proctor's vehicle. The audit produced results indicating that all three vehicles were queried by, I'll leave the individual's name out, a dispatcher in the local police department, CJIS account at 6:22:19 p.m., 7:05:43 p.m., and 7:10:44 p.m. respectively. This individual is employed as a civilian dispatcher. On Wednesday, September 22nd, 2023, Lieutenant Fanning and Sergeant Yuri Buchanek interviewed Webb at the Avon Police Department. Individual stated she been employed for a period of 3 years, and goes on to indicate that the query was made at the defendant's request. I'll skip some of this, Judge. The dispatcher provided her cell phone to investigators. Investigators observed communication between the dispatcher and Clarence Wood Emerson, the pseudonym used by the defendant, on a Facebook message or on the cell phone on September 25th at 6:18 p.m. Dispatcher sends the message, "What you got? I'm here till 8 a.m. Clarence responds, "Sorry, H500," which was a registration. After several messages back and forth, the dispatcher sends the message, "Matt McCabe," to which Clarence responds, "Got him. It's parked at Michael Proctor's house as we speak. Thanks, this is huge." Dispatcher responds with a message again, "Please keep me private. I don't anticipate fucking up in life and never want the wrath of you." At 7 p.m., Clarence sends the message, "Of course. Any chance you could run two more?" Dispatcher, "Sure." Clarence sends pictures of two vehicles parked in the driveway, at Wentworth Road. The dispatcher sent Clarence 80 blank numbers Proctor. Clarence then asked about another registration. "Is that Lizzie?" To which the dispatcher replied, "Yes, Lizzie, Elizabeth Proctor." Dispatcher said she has read Turtle Boy blog posts in the past and has followed his media regarding Karen Reed closely. A check of Webb's Facebook page information publicly available believes she is friends with Clarence Woods Emerson. Dispatcher has posted numerous posts and comments on content on Facebook supporting Karen Reed's innocence and copying Kearney's claim of police cover-up. On a YouTube video posted on October 2nd, 2023, Kearney acknowledged it is illegal to obtain information about the registered owner of a motor vehicle and discussed why it should be legal. I interviewed Jennifer McCabe regarding the incident. She stated she had never met Elizabeth Proctor or Michael Proctor prior to September 2023. Since the first meeting several weeks ago, Jennifer and Elizabeth have communicated regarding the constant harassment, intimidation, and public attacks. Jennifer stated they bonded over sharing the ongoing experience. She traveled to Elizabeth's home to discuss the harassment they had both been subjected to. Based upon the foregoing facts, it's probable that Aiden Kearney committed the violation of Massachusetts general laws, which is section 13B, witness interference, intimidation of a witness, Michael Proctor and Elizabeth Proctor, and the statute, pertinent parts read, whoever willfully, either directly or indirectly, threatens, attempts or causes physical, emotional, or economic injury or property damage to, conveys a gift, offer, or promise of anything of value, or misleads, intimidates, or harasses another person who is a witness or potential witness, person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order, a judge, juror, grand juror, attorney, victim witness advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer, or D, a person who is or was attending, or a person who has made known an intention to attend a proceeding described in this section, or a family member of a person described in this section, with the intent to, or in reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk's hearing, court order, mediation, or any other civil proceeding of any type, or punish, harm, or otherwise retaliate in any way against such person described in this action, for such person or such person's family members' participation in any of the proceedings described in this section. And it goes on to state the penalties for that offense. Based upon the foregoing facts, Commonwealth believes it will establish a trial that Aiden Kearney committed the violation of Massachusetts General Laws, Chapter 274, Section 7, conspiracy to commit intimidation of a witness by entering into an agreement with the dispatcher named earlier to obtain sensitive information to be used in blog posts and videos intended to harass, intimidate, and cause emotional harm. And given the continuing harassment of witnesses for the murder of John O'Keefe, we believe that the defendant will be found guilty at time of trial should this matter go to trial. That judge, that recitation deals initially with Elizabeth Proctor, the wife of Trooper Proctor. Now, there are an additional 8 complaints that I have here, Judge. Much of the verbiage is that's recited is also recited in these complaints, as they obviously have to independently stand on their own. However, for purposes of this arraignment, I can skip forward, Judge, and go to just the pertinent sections for the individual victims / witnesses, because they are both in this matter. But Juliana Nagel, on Saturday, July 22nd, at approximately 1200 hours, Kearney departed Shaw's 134 Nathan Street in Norwood, accompanied by a number of motor vehicles for something publicized as a rolling road rally. Kearney began a YouTube live video. The YouTube Live allows users to broadcast live videos on the YouTube platform, which can be later saved and distributed on the user's account. At the beginning of the video, Kearney is operating a motor vehicle and stated at least 100, 200 people are in the caravan of vehicles. He further stated that he did not broadcast the locations of the protests prior to the departure of the rolling rally. During the video, he stated, this defendant stated, the purpose of the rally is to protest the murder, cover-up, and framing of an innocent woman. He stated some witnesses will be in jail within a year and brags about being to locate witnesses wherever they travel. During the duration of the rally, he thanked other members of rally for attending the rally. Juliana Nagel, 25 years old, lives, I'll omit her address, in Canton with her 2 parents and 2 siblings. Juliana was home with her mother at the time of the protest. Juliana and her brother were present at 34 Fairview Road and had been interviewed by investigators. When Kearney arrived at 79 Highland Street, he identified the residence as her home. Kearney made a statement to get the attention of her neighbors. He described how O'Keefe was beaten to death at a house where Juliana was present. He stated at any point, Julie Nagel, you can come out at any point Nothing is stopping you from telling the truth. You know what happened that night. He continued to state, you can't get away with it anymore. Too many people know. You're going down with them. Nothing is stopping you from coming.
Okay, real quick. Julie Nagel that he's talking about is she's her picture's not on here. She was at the house that night that John O'Keefe was killed, and according to all of the court documents, they had Julie had called her brother to come pick her up, and her brother was Ryan Nagel. Ryan pulled in or pulled down the road right behind Karen and John. Karen was driving. They pulled up in front of the house and were parked right behind them. And according to his statement, Julie Nagel came out to the car, was talking to him and his friend and the girlfriend that were all in the truck, came out and was talking to him, and then decided she was going to stay. So she went back inside. So when Ryan Nagel drove off, he saw Karen sitting in the car, in her car with the interior light on by herself, and there was no damage to her car. So why that's a big deal is that means that, like, you would conclude from that John, if he's not in the car and he wasn't around the car, he had gotten out to go inside. Also, there was no damage to her car when he drove off. And so if there was no damage, then there was no shattered taillight, which means she didn't hit him. So it's a huge thing. Also, Julie came out to talk to Ryan Nagel. So she would have come out and seen everything that happened and seen him go in. So that's who they're talking about now.
Coming forward and telling the police what happened. Kearney claims Nagel lied to investigators about her observations the night of O'Keefe was killed and is complicit in the cover-up of a murder. Kearney stated, you might as well tell the truth and let the world know what happened. Neighbors, maybe you guys can help us pressure them into this. Julie Nagel was involved with, was at the murder of a Boston police officer. She knows what happened and she is actively involved in the cover-up. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. The truth will set you free. Kearney is in front of the residents for approximately 10 minutes. At the conclusion of the speech, he stated the next location
It's my podcast.
the home of a Canton Police Department Deputy Chief, Thomas Kelleher. While traveling to the next location, Kearney stated Julie Nagel's house was a good one. They were home. And clearly, the statements he made there, Judge, is about as far as it can go. During a recorded interview on WristFlex, dated August 20, 2023, the defendant made comments about his influence on the jury pool. I want the world to know what happened here. They want the story to be silent. Nobody knows about it. They want to be able to find a jury pool that has never heard any of this shit before they can manipulate them the way they manipulated everyone else. And I'm not allowing it. Not allowing them to do that. Happy to do it. Elite mass corruption. Turtle Boy. 104 mark. Based on the foregoing facts that I've read, Judge, it's clear that the defendant committed the violation.
Yeah, huge fight with Wendy Murphy.
13B, which is intimidation of a witness and witness interference with Juliana Nagel. I will not recite the paragraph that I recited earlier as to what the language of the statute is. And for this reason, Judge, on the second complaint docket 1151, we're going to be requesting those same conditions of release. Does it have about perhaps another hour going on wants to take a break or keep going, whichever your honor indicates?
So let me ask you this, the issue with bail and release conditions.
Yes, your honor.
So, I mean, haven't you covered that?
Well,
Why should we put a bail on and certain release conditions?
There are, Judge. There are other witnesses, so I would ask that those conditions apply to each of the docket numbers. The facts are fairly similar But as there are different witness/victims in these cases, the specific facts vary. But they're generally the same content as
I understand.
as the
The
toy break.
complaints issued, which means that the clerk magistrate found probable cause to issue the complaints. So that's been established.
Correct.
And, I mean, if the alleged victims in the various cases were to be named, then we would, to the extent that I allow any or all of your proposed conditions, it would encompass those people, wouldn't it?
It would, Judge.
Yeah.
So I would ask Your Honor to adopt the Commonwealth's recommendation as to the conditions.
Attorney Reynolds, if you
Yes.
could go to the microphone, then perhaps. Attorney Novak-
He wanted me on the show. I haven't.
Tell me,
I
what
haven't.
is your position with regards to the
Chance.
Commonwealth's request for cash bail in the amount of $1,000 and the various conditions?
Yes, Your Honor, as far as the bail, we're asking for release on personal. He has no record. He lives with his family in Holden, and he has 2 children that he supports. And what we're providing here is that we don't believe that because of his record or because of his commitments, that he would be a danger of flight or creating a problem in terms of needing bail. As far as the conditions go, my client states that he is a news person who is using his First Amendment rights to cover a story. Now, I know that he is doing it through YouTube and social networks, but there are a lot of people who do this. And he is requesting that he still be able to do this news coverage. He vehemently denies that he's intimidating or harassing anyone, that the trooper involved is a public figure, that there is a potential selectman involved, that he goes to meetings, and he feels as if that he should be allowed under his First Amendment right to pursue his story. Now, as we go through it in terms of the threats, I just would like to point out that when I read the statements that the prosecutor stated, I see opinion. I don't see threats under the way my client is acting. I said from the beginning, I don't want to go to trial. Most people don't want to go to trial. That's an opinion. That's not
He
perceived.
said he didn't want the Cameron Reed case to go to trial.
Okay. But still, it's an opinion, and he put it out on the web. It's really important for the people in Norfolk to know about this story because the jury was chosen from that. Again, opinion. Again, the internet allows for that. I'm sure that, or I would hope, that if any of these statements would have violated YouTube policy, they could have contacted that and had it all taken down. In addition, I would provide that this is a lot of reports, and for some of these conditions to apply, such as controlling his followers, not sure how you do that. I would believe that if he were allowed to continue to pursue the story with his bail warnings, that the police could access or take a look at further events that he does. Meaning that if he calls for one of these rolling rallies, someone will give a call, they can go out and they can determine whether or not it's intimidating or if there's a charge that applies. I mean, that's what I'm arguing, to allow the First Amendment to go forward and to allow the prosecution to continue to monitor the situation. They have police involved, and then each event that comes out of it is under bail warrants. If he does something wrong, he's back here. And that would be my argument.
All right, thank you. Attorney Mello, if you would, for the court and police department, would you identify the alleged victims in the various complaints by name? I think I have them all, but I want to make sure.
I will, Your Honor. In the first instance,
Yes, that's
it
the
is
one.
Juliana Albert.
That's Julie Albert.
In the second instance, Judge,
She's married to
it
Chris
is
Albert.
Christopher Albert.
That's Christopher Albert. He's on the select board.
And those are, these are in addition to the ones I've already identified, Judge. In the next instance, Judge, it is Michael Proctor.
Michael Proctor's the lead detective, investigator, whatever, who's very close to the Alberts, longtime family
And we
friends.
have
And actually, Colin Albert is the only person who's ever had a problem with John O'Keefe, and he was in Proctor's sister's wedding. But the DA says they have no connection. They have no personal connection. It's all over Facebook.
This, the intimidation of a witness with a co-conspirator was, there were two victims in that matter, Judge. Jennifer McCabe and Elizabeth Proctor. Those were incidents where the vehicle registration was run. We have Jennifer McCabe. We have Matthew McCabe, and that is the remainder of the complaints so far, Judge.
That is a list, if you will, of the alleged victims in the case as to which you're seeking specific conditions.
Yes, Your Honor.
Thank you. All right, in my view, given the individual's lack of criminal record, I don't, it's not a cash bail case. I'm releasing him on personal recognizance. Also, I don't see it as a GPS case. I am not opposing a GPS. What I am doing is opposing the following conditions. Stay away, no contact from each of the named witnesses that were just listed by Attorney Mello and captured by the court and the probation department. Stay away, no contact. That means direct or indirect, including but not limited to mail, email, text, telephone, social media, or any via any other mechanism, if you will, direct or indirect from all of the named alleged victims. Mr. Reynolds, I'm sure you'll advise your client that that is broad, and that is broad from my view on purpose. And if it comes before me or any judge, and a judge would find that he violated a release condition, he is subject to incarceration for up to 90 days without bail. Thank you. We need a date.
12/5.
Did you coordinate that? Mr. Mello, what's the comment? That's a little far out.
We'll find this fine, Judge.
It's fine, okay. All right, that's it. What's that? No.
Tracy, I never said that bullying and intimidation is okay. We're just watching a hearing.
For your parents back in December 5th, from the trial hearing, the position that you stay away and don't contact directly or indirectly with the victims that were listed. You'll need to sign those conditions before you leave the courthouse today.
Oh gosh, the Zoom stuff. You hear them?
That's all we have.
Thank you.
What? All right. One chance to recess, but please, courtroom, please.
All right, so that's the who's who. Basically, you know, like I said earlier, the approach that he has is, what word did I use? Abrasive, I think. But like I said, his goal is to bring attention to this. So he, and Lord knows he's done that. But this chart is on 13jurorpodcast.com. But it goes along with the conspiracy in Canton stuff from the podcast. Are they closing? Shit, how far are we back? Let's see.
So that concludes my reading of the instructions to you on the law. With that, is the
Perfect
state ready
timing.
to proceed with its closing arguments?
Perfect timing.
All right, Ms. Coakley, you may
All right, well, we can listen to the jury instructions when we go into verdict watch. This is perfect timing.
proceed.
Closing arguments.
want to start by thanking you all for your time and attention. I know this process has been a longer one than any of us estimated, and at times, a lot of the time, it can be tedious. But this process is an important one, and the decision you're about to make is an important one. From the outside, the Ferriter family looked in a lot of ways like an ordinary family. 2 parents, 4 children, the kids go to school, there are activities, the daughters have bedrooms, normal, ordinary to the outside. But what has been established, what has been proven through the course of this case is what was happening inside that house was anything but ordinary. We learned that over the course of the time that Ronan Ferriter was in Jupiter, Florida in December 2021 through January 2022, he was subjected to treatment by his parents, including his father, Timothy Ferriter, that was cruel, heinous, and malicious. That under or behind the facade of an ordinary family, there was the treatment and isolation, the systematic isolation and confinement of Ronan Ferriter when he was 14 years old, in that room, in their garage. And that's why we're here today, because this treatment, this systemic way in which he was forced to live is a crime. Now, I want to talk specifically about the law in the case, and you just got it from the judge, but I want to talk for a few moments about some of the specifics and explain it. You heard that your job, the rules for your deliberation in this case, your duty is to determine whether or not the defendant has been proven guilty or not. It is not your job to make a determination if he is found guilty, what, if anything, the punishment should be. That role is left to the judge. And so that means that everyone in this room has a very specific job. The state has a job, the defense has a job, and the judge has a job. And you, as a jury, are here to answer the specific question. Did the state prove its case beyond a reasonable doubt? And in answering that question, the law tells us that your verdict cannot be influenced by feelings of prejudice, bias, or sympathy. So if you're back there and you feel that, I feel bad for the victim, or I feel bad for the situation that the defendant is, that is not something that can influence your verdict. Now, in applying the verdict, there are 3 questions or 3 crimes at issue here. I want to take a moment to kind of talk about each one of them. I'm going to go backwards, count 3, and then count 2, and then count 1. So count 3 in this case is child neglect. And basically, there are 3 elements that the state has to prove beyond a reasonable doubt. Elements 2 and 3 are not really in dispute in this case. The child in this case was under the age of 18 years old. He was a child. You heard that during the time period that's at issue here, he was 14 years old. And the defendant was his father. And in Florida, a person that is a father is a caregiver. So 2 and 3 are not really at issue. Now, to prove element 1, we have to show that he willfully or by culpable negligence failed or omitted to provide Ronan with the care, supervision, and services necessary to maintain his physical and mental health. And we're going to go in detail, again, as we've done throughout the entirety of this case, about what the evidence, about how it proves that there was neglect. But you heard from Ronan and also from the expert witnesses in this case that they did not try to address any existing mental health issues from at least 2019 was the last time any of those were addressed by a professional. And instead, what they did was systematically isolate him and provide no treatment and have him live in a way that the experts told you would be neglectful and detrimental and abusive to any child. Now, count 2 is false imprisonment. And to prove that, we have to show that the defendant forcibly, secretly, or by threat confined or restrained RF against his will. And so, confined, imprisoned, or restrained. Here we have direct evidence of that. You can hear over and over and over again. And we went through every single day that we have on video in the room and locked the door. The second element is that he had no lawful authority to do so. There is no lawful authority. There is no right in order to confine a child like this. That's talking about like if you're a police officer. Did you have the lawful authority to arrest someone and put them in jail? That would mean we wouldn't be able to prove that. But the defendant in this case has no lawful authority to do that in the manner that he did. And we have to prove that it was against Ronan's will. And we had his direct testimony as to that. Now, I want to talk about count one, which is the aggravated child abuse. There are two elements to aggravated child abuse. The first is that he willfully tortured, maliciously punished, or willfully and unlawfully caged RF. And it's important to note here that these are ors. So it's in the alternative. It doesn't have to be all of those. It can be any one of the three. So if you find that we've proven beyond a reasonable doubt that he willfully tortured, then we've met element one. Or instead, if you find, based on the testimony of Dr. Myers, that it's actually malicious punishment, then that is proving count one, element one. Or if you find that based on the circumstances and where he was kept, locked in that room day after day, that that's willfully and intentionally caging, that's enough. And then we have to prove that he was under the age of 18, which there isn't much dispute here because he was 14. Now, the courts or the law gives us a definition of what malicious means, and that applies to one of those alternatives, which is malicious punishment. And that means that he wrongfully, intentionally, and without legal justification or excuse, it may be established by the circumstances. So in jury selection and opening statement, there was a lot of discussion about how do you know someone's intent. The law is that you can look to the circumstances. You can make reasonable inferences from the evidence. And it's from the circumstances from which one can conclude that a reasonable parent would not have engaged in these damaging acts towards a child for any valid reason. And that the primary purpose of the act was to cause unjustifiable pain or injury. Now, you also got an instruction as to reasonable punishment. And in Florida, you can find the defendant guilty if you prove that we have proven beyond a reasonable doubt that the defendant was not a parent, which is not the case here, or if we've proven that the defendant's physical discipline of RF was not reasonable for misbehavior under the circumstances, not reasonable. If you find that it was not reasonable, you have to find him guilty. So I want to talk for a second about how this instruction applies to aggravated child abuse. This instruction is talking about corporal punishment, right? And we talked in jury selection about spanking a child or not spanking a child. There are circumstances in Florida where it is permissible to use corporal punishment against a child, but that has to be reasonable corporal punishment. So an example would be spanking a child.
Overruled.
Right? And so when we're evaluating whether or not this applies, about whether or not something meets the definition of reasonable corporal punishment, we look, one, is it reasonable? And two, is it actually corporal physical punishment, which is not the case here. Here we have intentional caging of a child, which is not corporal punishment under the circumstances. Now, you also got an instruction about lesser included crimes. And so the law is that sometimes there are crimes and then there's a lesser included crime under it. And when evaluating a lesser included crime, you start at the top and you make a determination first if we prove the top crime. In that case, it would be aggravated child abuse. If you found that we have proven that crime beyond a reasonable doubt, you don't need to go and look at the lesser included offenses. The same is true for child neglect and the lesser included crime is culpable negligence. I want to talk about kind of what the lesser is really quickly on each one. The lesser included crime is child neglect, is culpable negligence. For that, you just have to find that the defendant exposed RF to personal injury, and he did so through culpable negligence. The reason why this isn't really appropriate is it's subsumed in child neglect. And this doesn't take into consideration the fact that there's a parent-child relationship here, and that the person that the action is toward is a child. This could be any adult action towards another adult. Now, as for child abuse, which is the lesser of aggravated child abuse, there has to be an intentional infliction of mental injury or that the person committed an intentional act that could reasonably be expected to result in mental injury. So again, when we're talking about intent, how does the state prove intent? You don't have to prove, or we don't have to prove the thoughts in someone's head. That would be impossible.
Thank God.
But we have to prove that there was an intentional act. So this defendant made actions with intention, meaning it's not an accident. He didn't accidentally build the room in his garage. He didn't accidentally lock his child in day after day. He didn't accidentally make it so he didn't have a bathroom. That's what the types of intent mean under the law. Don't make me do it.
Well, only when you move away from the mic.
The whole time.
That's why I said give her the mic.
So, and that is what the instruction of child abuse means. So, what you have heard from the judge and what is clear is what is not an element of a crime. What is not something that we have to prove in order for you to find the defendant guilty. We do not have to prove that every minute of the day the defendant abused his son. We do not have to prove that he was subjected to that abuse at every second of the day. It can be still child abuse when there are times where you are kind and treat your child appropriately, and then other times abuse the child, which is what is happening here. We do not have to prove to you his confinement was 24/7. There's been a lot of discussion about, well, there were times where he was let out. Absolutely. The state agrees. Ronan agrees. His sister Fiona agrees. That has always been what they have said, what they have discussed about what happened to him. It's not every moment of the day. There are lots of times where they look like an ordinary family. It's what happens behind the closed doors, which is why we're here. We do not also have to prove that the victim was starving, that he was malnourished. That has never been our contention or the state's claim. We agree that he was not clinically malnourished. The issue with the food is that they systematically controlled and regulated him to an extent where it became abusive. There was social isolation. There was lack of access. There was lack of autonomy to a level in which it was objectively harmful to any person, but specifically to Ronan. That's why the food matters. Yes, he got dinner. He got breakfast most days. You can see on the video, there's 1 or 2 days that as a punishment, he does not get dinner. But we sat here and watched him over and over and over again, eating his meals alone in his room. It also is not a legal defense that a child has some type of diagnosis, a mental health issue, a substance abuse issue, a behavioral problem. You know, whether or not a child is born with a mental health issue or an intellectual disability or a behavioral problem, or an adopted child has those things because of trauma, because of genetics, because of a roll of the dice, that could happen in any case, adopted or biological. That is not a reason or a justification to abuse a child. And that's what the law is. And that's why you're not going to see that in an instruction that it matters at all. It is also not a legal defense that a child has behavioral problems. It's not a legal defense that it was hard, it was difficult, it wasn't as easy as the other children. It's not a legal defense that we tried other things. There's no justification legal for what happened here. It's also not a legal defense that we did not get good advice. Now, you're going to get the form in the form of the verdict. There's actually 3 counts, but I just showed 2 here. And I want to make clear that you make a determination, you just check one of these, but your determination on one charge can be different. So that means that you can find him guilty of one charge and not guilty for another. The evidence applies to all of the charges, but your determination doesn't have to matter. And some people people get worried that it's going to be like on TV and the foreperson's going to have to read it out. That's not how it works in here. The clerk will read it. And this is the kind of the instruction that tells you that law that I just talked about, that a finding of guilty or not guilty as to one crime doesn't have to affect your verdict as to the other. Now, there is one instruction here that we haven't talked about a lot at all, and it's called the principal instruction. And you probably noticed that we have presented evidence of both actions and statements made by Timothy Ferriter, and also actions and statements that were done by Tracy Ferriter. And that's because although they're being tried separately, they're both charged. And so that means in cases like that, if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person did. So they're co-defendants and can be jointly responsible for that action. So you don't have to, in your deliberations, make a separation between who did what. They are acting together in this criminal acts. Now let's talk specifically about the evidence that has been presented. First, you had the testimony of RF or Ronan, and he testified, and one of the first things that he told you and that I asked him about is how he felt about the treatment by his parents. And he told you that he found that treatment to be dehumanizing. He did not want to live in that structure in the garage, and that the defendant forced him against his will.
That was sad.
I asked him, well, what would have happened if you refused to go in the room? And he told you that he would have been physically forced to enter that room. He would have been dragged against his will. He also told you that although he did not spend all time in that room, he did spend large portions of his day confined in that room. He told you that every single night he would be locked into the room without access to a bathroom, that there were large portions of the day where he would be locked in. Occasionally, a time or two, he would return from school, be put in, and be not let out until the next day. He would eat many of his meals alone in the room, and there was periods, more than once, where he was in the dark during the day. And, you know, on cross-examination, Ronan also told you that, yes, it's true, he can remember the good times because their abuse of him wasn't absolute, but what their actions taught him. They taught him that his needs, personal, social, physical, did not matter. They taught him, they reinforced that he was bad and that the cruel and inhumane treatment is what he deserved.
Wow.
They taught him that it was his fault, that he deserved this treatment. And we can still see the impact of those lessons on Ronan today. It was apparent when he testified that those lessons, what the defendant's treatment did to him, are still there. And we see that those lessons haven't faded. And we could see that in some of the statements that he made. You could see that despite cruel, inhumane, systemically bad, harmful treatment, despite that, those people, the defendant, are still the only parents that he's ever known, that he still wants to please them.
Action, facts, non-evidence, and proper argument.
For a child, and you heard it from both Dr. Myers and Dr. Rappa, for a child, this type of behavior can be normalized. It's complex. It's confusing to have the people, the only people in the world that you are supposed to love and trust, to systemically treat you this way. And so for him, for Ronan today, as a 16-year-old, still a child, he needs to call it a mistake and say that they should be forgiven. But that's not what the law is. The law, when we look, Karen, sorry, did it again. When we look, we see that this was a systemic, harmful, cruel action by those people that he loved and he trusted. And under the law, it's something that's called child abuse. Now, in evaluating the testimony, we also have the testimony of Ronan's older sister, Fiona, who is now 17 years old. And so when this was happening, she's about 15, 16 years old for the time in Florida. And in that white box is one of the instructions you got, and it's about evaluating the credibility of witnesses. And in evaluating the credibility, one of the things that we look at is, does the witness's testimony agree with the other testimony and other evidence in the case?
Ms. Copley, carry the mic.
I never wanted to be like a pop star, and that's how this makes me feel. Does the witness's testimony agree with the other testimony and evidence in the case? Fiona confirms, yes, he was locked in the garage. She confirms the status of the room. She says that he had no other room in the house. She also says that the defendant is confined to that room for large portions of time in Florida, and that he is punished differently than his sister for the same action. She tells us that she was allowed to go to the bathroom. She had a room. She had access. And so did her sister Nola and even the baby Pierce. She tells us that at no point did she ever feel that there was any need for her to be protected from her brother, that she was never in fear for him, and that he never physically harmed her. There's one incident she can tell us about where he stole from her in Arizona. The defendant's actions towards the victim were normalized in the family. And I know that Fiona was really hard to hear because we did her through closed circuit. But as the judge told you, if it would help in your deliberations, you can re-listen to her testimony, and you can listen to the audio, not from this courtroom, but from the courtroom we were actually in. But there, at the end, on that second day, we talked about, did it just, because this treatment was happening so often, did it become normal? And she said it was. And she said that at the time, I didn't have a name for what was happening to him, but I do now. And it was abuse. And then we have the testimony of Dr. Myers, who's an expert witness, a child psychiatrist who is still actively treating patients and a professor at Brown University. And he told us that based on his review, that the defendant's actions were malicious, cruel, and sadistic, that they constitute torture, that there was no legitimate justification for this ever, and the only reason that you do this is to harm someone. He told us that that treatment of Ronan resulted in psychological harm. He told us that it was emotional deprivation, psychological deprivation, and a physical deprivation, and that leads to a psychological impact. In those cases, it leads to a child that is withdrawn, isolated, depressed. It can lead to suicidal ideation. It can cause existing behaviors to deteriorate. So if you take a child that maybe has some pre-existing trauma, that has behavioral issues, it absolutely under no circumstances will correct or treat any of them. It will only make it worse. He told us that it will stunt psychological and intellectual growth of a child. He told us, and we just had a lot of discussions about reactive attachment disorder and whether or not that is appropriate here. He told us that there are indications that there may be an attachment issue, but that the defendant's actions would increase and exacerbate any attachment issues. That this is the worst thing that you can do for a child for attachment issues. He also talked about post-traumatic stress disorder and told us that the defendant's treatment alone is a traumatic event that can be a precursor to post-traumatic stress disorder. And that's what he thinks is happening in this case, because he agrees that there is PTSD apparent here in Ronan. He told us that even if they're not the original cause, they're not the chicken, they're not the egg, that it would make any symptoms worse. And there's been a lot of discussion about diagnoses and what it is and what caused it. I want to be clear. That does not matter what diagnosis there is or is appropriate or correct. It is not a legal defense. If a child has reactive attachment disorder, it doesn't mean you get to treat them however you want. What matters here is that there is an indication that the child may have been medically vulnerable because of past trauma. And instead of doing anything productive to assist that child, they did the worst possible thing you could do. Now, beyond the direct testimony, the photographs in this case, we have hours of Ring camera because the defendant recorded every
Hours
single
and
moment in that
hours.
room. And like we said, it's not a continuous stream. It's 1 minute videos related to action. But we have hours of the treatment, of the confinement to prove, to corroborate what Ronan said, that he was in there alone.
You want to take this thing to the next level? Let's do it. Let's do it in Florida too. Let's do it in Florida too. Let's go.
And so you don't have to take Ronan's word for it, that the treatment was extreme, that it was dehumanizing. We have the direct evidence of his actions. This is not a concerned father trying to make a reasonable correction to a behavioral issue. This is a man that is angry. This is a man that has actual malice, that has physical aggression and anger, because we see him put his hands on him, throw him on the bed, put his hands on his neck, scream on him, and then turn out the lights. And so his son,
That's bad.
is in an 8x8 box. The area that you're sitting in is bigger than that. Oh,
Sustain.
you can use your common sense for how big 8 feet is. Alone. And remember, we're looking through a camera that is has some night vision capabilities. Ronan told us what it's like to be in there, that when the lights are off, there is no ambient light. There is no window, that he's sitting in the pitch dark. So let's talk about the application of the evidence to the law. Aggravated child abuse. Malicious means wrongfully, intentionally, and without legal justification. What's in establishing or evaluating what is reasonable punishment? Is it corporal punishment?
Rang that bell. Yeah.
Things that are generally accepted as being a corporal punishment. A strike on the hand. Hitting a child on the back of their behind in a direct response as a punishment. Reasonable corporal punishment. Reasonable punishment does not subject a child to a risk of harm. And it does not cause actual harm, like the case here. It is not humiliating, dehumanizing, and cruel. It is proportional, and it is limited in duration. So let's talk about the duration here. Continuous. This is ongoing, and I think that's an important delineation here, right? This is not a proportional reaction to a behavior, like a discipline or a punishment. He has no other room in the house. There is no other place for him. Every other space is taken up. The parents have a room. Each of his daughters have a room. Pierce has the office. So there is no situation where he conforms his behavior to whatever standards the defendant wants, and then he is out of the structure in the garage. This is his life. Continuous. Even in the best case scenario. But we know that it was more insidious than that, because we look at the duration. January 6th. He goes in at 8:10 p.m. That's when they lock up the door for the final time. No more bathroom, no more glasses of water, certainly no snacks. The door's not open until 7:10 in the morning. He's in there for 11 hours overnight. January 8th, he goes in at 9:39 p.m. January 9th, the door is not open again until 8:35 in the morning, 11 hours. January 9th, 8:36 to 7:39. January 10th, 8:36 p.m. until 8:25 a.m., 12 hours. No bathroom, not a drink, not a chance of getting a snack. No way to escape if there is an emergency or a fire. Locked, deadbolted inside. When we look at January 13th, 4:49 p.m. to 6:18 in the morning, 13 hours on a regular basis. And the exhibit that the state showed you, all of the Ring videos are in from that entire time period. But then we showed you hours of videos that showed every event. So him going in, and then when they come in again, he gets out. So those are the major blocks, the major events. When they come in, they go in, they out. And those are the numbers that we're talking about. When we look at the total in a day, okay, fine, not just overnight. How much of a 24-hour day is he in the room? On January 10th, he goes to the bathroom between 7:39 and 7:45 a.m. or 7:43, so that's when he's let out. He leaves the room at 9:05. He told us he got left around 9 to go to school. And then he returns to the room at 4:59, so after school. And then he leaves the room to go to the bathroom at 5:56 to 6:18 p.m. And then he's in. So 12 a.m. to 12 p.m. is 14 hours and 22 minutes of a 24-hour day, and he went to school. Huge portions of this child's life are alone in this room. On January 13th, same thing. He goes out for 2 minutes to go to the bathroom at 7 o'clock in the morning, almost 8. He leaves the room to go to school at 9 o'clock. Back in the room at 4:49. He gets dinner at 7:02 and lights off at 7:26. He's in there for 16 hours. If we're going from 12 a.m. to 12 p.m. And he went to school. January 20th, same thing. 6:43 to 6:45. Leaves the room at 9. Back in at 4:45. This time without the lights on. Dinner at 7 p.m. Now, was this every single day? No, because as we look at January 23rd, he gets unlocked. He gets released from the cell his father made for him at 9:07 a.m. and he's not back until 7:10 a.m. So yeah, he's out for most of the day this one day. That doesn't change this though. The psychological impact. And when we look at the proportionality, it's important to remember that the time frame that we are talking about is the crimes that occurred in Florida. And so that is from December 2021 until January of 2022. You can see the things that he is getting in trouble for on that video. He's getting in trouble for stealing candy on that very first night. You stole chocolate from us, his mom says. Having an iPod in his room. Having a bad attitude. Lying. She tells a story about having a mock trial, and that wasn't true. Dr. Myers told us that kids subjected to this type of condition can have a fantasy life because they have nothing else going on. And so they have to have like a myth of themselves. Those are the things in Florida that he is being subjected to this type of treatment for. And I want to talk a little bit about intent because there was a lot of discussion from the defense about intent. How do we determine someone's intent? For aggravated child abuse, it has to be that they maliciously punished, willfully tortured, or willfully caged. Those are intentional actions. We have to prove that the actions that they took were intentional, that he intentionally and purposely put him in that room, in that structure.
Objection, misstatement of the law.
Overruled.
That it wasn't an accident. That's the intention. That he willfully tortured, that he maliciously punished. Not every idea that was in his head. So how do we determine as a jury intent? We look to the evidence. You can make reasonable inferences from the evidence, and we look to his actions and then the things that he said in those circumstances. So let's look at the defendant's actions. That he did not give the victim a room in the house. He hired a contractor specifically to build this. He specified no windows, 8x8, lights controlled from the outside, lock, and a deadbolt from the outside. No bathroom. And he put that bucket in there. Each one of those steps are intentional, specific, deliberate acts. It's not an accident that this happened like this. We know exactly what he intended to do to his son. He set up the room. He put the camera in there. And then he forced the child to use a bucket. This is a screenshot from January 19th at 6:46 a.m. where he has to use the bucket. He had been in the room since 9:12 p.m. the night before. And this happened again and again. And in the morning, on one of the videos, you can hear the defendant tell him to take out the bucket and say, your neighbors don't need to see your piss bucket.
Yes.
From
She's
the
doing
outside,
great.
everything looked okay. But what was happening inside that room? Abuse.
She's doing great.
We see that the defendant's repeated actions to socially and physically isolate the child over and over and over again for hours last week. We watched Ronan alone in his room eating. And Dr. Myers told you about the impact of that type of social and physical isolation. His actions to take away every little step and bit of autonomy that he had no control over the temperature even in the room.
Okay.
Did you turn the air on in your room?
Yes.
You're supposed to touch that? Did you hear Baba?
Yes.
Did you hear his question?
No.
Are you supposed to touch air conditioning?
No.
Why did you touch it?
It was getting hot.
I don't give a shit if it's getting hot.
Ugh.
You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
You know, in opening statement, defense counsel said that there was just a design flaw in the room. It's not a flaw. These are intentional choices. This is what he wanted to happen. This is what the environment that he intentionally subjected his son to. An environment that no reasonable person would think was appropriate or acceptable. And then after they have that conversation, both parents come in and ransack the room again and leave him with even less stuff sitting in the room. We have the defendant's actions, his choice that not only would he substantially socially and physically isolate his son, but that they had to subject him to hours of sitting in the dark.
So you have an answer? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here?
What we have here is anger and derision. We have spite, and we want to cause him harm. That's why you're not trying to address behavior. What you're trying to do is maliciously punish him and make him sit in a dark cell for hours during the day. When we look at, oops, one more. This one.
It is taunting. That's not.
This is a few minutes later.
So you have an answer? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here? Bad answer? Yeah. All right.
So when we're talking about like the reasonableness of the punishment, like look what he's doing that for there. He has a bad attitude. His 14-year-old son has a bad attitude. And that's why he gets to be locked in a room with no lights, which Dr. Myers told us is the same as solitary confinement, something that is universally condemned for most humans, but certainly for children because of the psychological harm that that type of treatment caused. And we can see about how often that type of thing is happening. The camera is installed in the room on January 5th. That's the very first video we watched. And we went through each of these. We see that on January 9th at 8:36 p.m. They're mad at him. He's in the dark. No ambient light. A 4x4 room. On January 10th at 6:18 to 7:06. Again, dark. On January 11th, 4:45 to 8 o'clock at night. And he doesn't get dinner that night because they're mad.
Ms. Coakley, pull the mic up because it's a recording issue for me.
Because they're mad. No dinner. On January 13th, again, 4:49 to 7:02, 2.5 hours in the dark in the middle of the day. And then they come in, and at 7:55 again for the rest of the night, pitch dark, no ambient light, not a window, 8x8. On January 14th, again, 4:49 to 7:02, he is sitting alone in the dark. Like Dr. Myers said, systemic, ongoing psychological torture of a child. January 15th, 5:04 to 7:32, 2.5 hours more in the dark. On January 19th, 7:45 p.m., those lights get switched off again. On January 20th, 4:45 to 5:51. January 24th at 7:08 p.m., he's in the dark. And then January 28th is the last day. It's the day that he runs away. The defendant made deliberate, intentional actions. He put his child, a child that he knew was vulnerable because of his early childhood experiences, into this circumstance. Every single night, for periods of time during the day, he locked the door over and over and over again and didn't allow him to even control the temperature. His only option was to use the bathroom in a bucket, and he had no access to water on multiple occasions. And then in evaluating his intent about what he is trying to do in this circumstances, we have what he says.
Tell me something? Stand up. Tell me something? What? Don't tell me what. This is your one chance. Don't look at me like an asshole. Do I tell me something or not? I have an accent. Yeah, from where? Blue Van. Where? Green Van. Excuse me? Green Van.
Same again?
What the fuck is wrong with you? You're feeling fucking like disappointing.
Chocolate and everything. You got so much stuff in your room.
Fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school. And you're gonna be in this room. You're this close.
Where are these in here?
All right.
This is like belongs to the kids or.
Let's get started. Very soon. See what your lion does? See what your lion does? You see it?
Is this
go back to this?
Is this to
So what we have is anger and derision. That's what's governing his decisions. And that's why we know that it's an intentional act.
Yeah, closings are 3 hours total. It'll take us to the end.
Stand up. Why are you giving people shit attitude? Fuck that. Don't say I don't know. Why are you giving a shit attitude?
I'm not thinking.
Fuck that. Why are you giving a shit attitude? Answer me! Before I get really fucking pissed off, answer me. Why are you giving her a shit attitude? When you're in school day, talking to your people to give you another opportunity, you got a fucking shit attitude?
And after this, when he exits the room, he again turns off the light and leaves him locked in the room. And so how does that impact our ability to determine or make a conclusion about what his intent is? This isn't about getting a productive response or even having a proportional type of conversation. This exchange is about him having a bad attitude. And you can see even here, where Ronan tries to say, I'm not thinking. That's why I'm having a bad attitude. And there is anger, aggression, physical, the specter of physical force, as opposed to having any kind of conversation with the child. And then the response is to not have a conversation with them, not try to do anything that would be useful. Instead, locks him in the dark in an empty cell and puts him, turns the lights off because he's mad. He has malice towards the child. Now, I want to talk for a second about Arizona, because I know that maybe it can be a little bit confusing. We've had a lot of conversation about things that happened in Arizona and what happened in Florida. The defendant is charged with the conduct that occurred in Florida. And the judge has given you an instruction about how to weigh that conduct and how that can impact your deliberations. And that instruction is that the evidence of those other crimes, wrongs, or acts can be considered for the purpose of proving motive, opportunity, intent, preparation, plan, knowledge, identity, or the absence or mistake of accident. So that means that when considering the defendant's intent here, you can take into consideration his actions in Florida. You can take into consideration that this is not just something that he suddenly came to in Florida, that it just happened for 30 days. You can take into consideration that this is something that the defendant had been subjecting his son to for a period of 3 years with, as Dr. Rapper told you, really no improvement, right? Like he was still having the issues that the defendant was concerned about, the bad attitude, stealing the sprinkles.
Sprinklegate.
And so despite the fact that it was not helpful, that it was harmful, he continued to do it. It's an intentional act, that he continued to lock his structure, that it's his child in that structure, that there was a bucket, that there was no control over the lights or temperatures, that he used physical and social isolation. That this is not just something, oh, let me give it a try. This is something that he had been subjecting his child to for years. And you can take that into consideration when determining his intent here, that this was his plan, that he wanted to do this, that it was not a mistake. You can also take into consideration the physical abuse that happened in Arizona and evaluating the evidence in this case about what he was doing and what he was intending to do. Fiona told you that there were instances where she could hear the victim screaming while he's being struck in the garage in Arizona. She told you that there was one incident where he grabbed the child by the neck and lifted his feet off the ground, and Fiona was worried that he might accidentally kill her brother. And Ronan told you about those incidents too. And the reason, although he's not charged for those incidents here, the reason they matter here in your evaluation of the evidence is because that threat of violence, the fact that the defendant's anger and aggression and grabbing him by the neck like he does in the video, of shuffling his arm, of getting up in his face, is not posturing. That threat of violence is very real and significant for Ronan. And you can see that in the videos. You can see him cower. You can see him stand almost withdrawn. But it influences what the defendant is trying to impose on him with those threats, and also Ronan's understanding of what can happen if he disobeys. So let's talk for a second about the defense case. They put on some witnesses, and for the most part, the first day witnesses were the defendant's friends, with the exception of the teacher. Those friends do not know and never were in Florida. They do not know what was happening when the defendant was alone in a home with his son, and they do not know the type of punishment that he was subjected to. And absolutely none of them have any firsthand knowledge of what happened in Florida, because they never came in Florida, they never saw anything, and they do not know. The defense also put on a number of videos that we spent the better part of yesterday afternoon watching, which are times where Ronan was outside the house. And what we see from those videos that we saw yesterday is that for the vast majority of the time in the recording, that the victim is able to conduct himself in a family environment. He plays nicely with his little brother Pierce, who seems to very much love him and want to play with him and is following him around and trying to get him to interact. He is able to behave appropriately with his other siblings. You see him playing with the dog. We do not see violence or aggression. You know, there's been kind of this idea floated that we had to keep the family safe. There is no evidence of that. The evidence is to the contrary. The person that was jeopardizing the safety of the Ferriter family was Tim Ferriter. We see that there are periods that he wasn't confined. And we agree with that. Ronan told you about that. When we look at the videos, we saw some videos of him on a scooter, which is on January 7th, 2022, after school. You can see in the videos that the state published that that's the outfit that he puts on. He leaves for school, comes back, he plays on the scooter. And then at 5:42 p.m., he's locked in the cell. And he eats dinner in there alone. And he's in there until he goes to sleep in the room where he cannot leave to get a glass of water or to get a bathroom. On January 9th, this is a Sunday, 8:45 a.m., the state's evidence is he's let out from the room. Then, like he told you, he was often, when he was outside of the room, having to do yard work. We see him in the defense exhibit moving those mulch. And you see in the defense exhibit, I took a close screenshot, but you look over, the defendant and his wife are sitting at the table while the child's working. And then later that same day, there's those videos. Like he told you, one of the things that he had to do was to clean up all the rocks. And the state put into evidence video after video of him out there by himself, by hand, taking up the shelves. You see the defendant come take a look and come back and say, every single rock. So yes, he did get out of the house, and sometimes he got to go on a scooter. Sometimes he had to do yard work, but at 6:25 every single night or earlier, he's locked in that room. The fact that on one day he watched a football game with his dad does not vitiate all the other days of systemic abuse. And then we have the testimony of Dr. Rappa. Dr. Rappa is their expert, a psychologist, and she told you that the way they chose to manage was probably the worst way that any person could manage these types of behaviors. She told you that the defendant's actions are the complete opposite of what anyone should have done with a child that has one of these conditions. She told you that there is a likelihood of psychological harm, even in children that had no underlying behavioral issues, that this is going to be harmful to anyone, but especially someone like Ronan. She talked about PTSD and reactive attachment disorder, and she told you that the defendant's actions would exacerbate the symptoms. That what he did made it worse. Actual harm. That is the defendant's own evidence. She says that this is not the recommendation that they received from any treatment provider. That she went through the records, and that what was recommended was medicine and therapy. And that there was very little of that done. And the last time that they dealt with any mental health professional for their son, who, according to the defense, they're so concerned about his behavior, was in 2019. The time frame that we are talking about is December of 2021 to January of 2022, 2 years later. No efforts. And we can see, and it's in evidence, you can take a look, when he is enrolled in school at the Palm Beach County School District at Independence Middle School in January of 2022, you fill out enrollment paperwork. And there, Tracy Ferriter says, normal dental, normal skin, normal eyes. Any concerns about general health? No. Any other specific illnesses or social or emotional or behavior problems? No. At no point did they try to get an IEP, an individual educational plan. At no point after 2019.
Objection, facts not in evidence as to the IEP.
Overruled.
We heard that, there was one email sent to someone about transcendental meditation, 2022. You know what else happened in 2019? Instead of doing anything productive to deal with the trauma maybe experienced by their sons or their behavioral issues, they locked him in the garage. Their biological son, Pierce, was born. They needed the bedroom. Ronan went into the garage. 2019 is when they stopped with the mental health professionals. In 2019, when that is happening. Those actions, what the defendant is taking, is not reasonable punishment meant to correct something. It is malice It is willful torture. It is intentional caging of a child. Now, Dr. Rappo, there was a discussion about what started the PTSD. Was it the defendant's abusive actions, or was it just his childhood neglect? And you got an instruction about how you can evaluate a witness's testimony. That instruction is that you get to use your common sense in deciding what is the best evidence. You get to decide what should be relied upon in considering your verdict. You may find some of the evidence reliable and some not. So you can say that some of what Dr. Rappa said makes sense to me and I think is appropriate in light of the totality of the circumstances. And some of it doesn't really line up. But our experts agree unequivocally the defendant's actions were harmful. They should never have occurred, and they would have led to worse behavior for the victim. That there was absolutely no benefit to what they did. Instead, they were harmful. In a criminal case, the state's burden is proof beyond a reasonable doubt. And the law instructs us on what a reasonable doubt is. A reasonable doubt is not a mere possible doubt, a speculative or imaginary doubt. Such a doubt must not influence you to return a verdict of not guilty. And so what does that mean? If you're back there in the jury room and you find yourself speculating, well, this is what they could have meant. And it's not based on evidence, it's speculation. The law is that you have to stop. If you find yourself forcing a doubt or imagining a doubt, the law is you have to stop. A verdict of not guilty can only be based on a doubt that is reasonable. And when we look at the totality of the evidence in this case, there are no reasonable doubts left. Now, one of the instructions that Judge Coach just gave you is what the lawyers say is not evidence, and you should not consider it as such. The exhibits, the testimony, the video recordings, that is evidence. What I say and what the defense says is not evidence. You get to use your common sense. Every single day in courtrooms around the country, we convene ordinary people and we ask them to use their common sense about what is reasonable and about what is appropriate and what evidence is proof beyond a reasonable doubt. For about 6 weeks, Ronan Ferriter was locked in a room in Jupiter, Florida. And yeah, he got to go to school, and sometimes he got to go on a scooter, and sometimes he got to play with the dog. But as you heard from Dr. Meyer, that doesn't change the impact of this type of treatment has on any child, but absolutely on a child like Ronan. The defendant's intentional, repeated acts caused harm. Any person would know, any reasonable parent would know that this is not acceptable. Any reasonable parent or person would know that this is going to harm. And despite that, over and over and over again, Tim Ferriter made that intentional, deliberate decision to treat his son like this. That's actual malice. That's intentional torture. That is willful caging. It's aggravated child abuse. It's child neglect, and it's certainly false imprisonment. It's not just one thing or one moment. It is all the things over and over and over again. What the defendant did was a crime, and that's why we're here today. Like Ronan told you, it was dehumanizing, and it was traumatic, and it should never have been done. Based on all of the evidence, that is why we are asking you. All of that evidence, those hours of tedious videos, and I know it was tedious to watch them, but the reason that we did is to see just a moment of what that tedious life was like for Ronan here. based on all the evidence and based on the laws of the state of Florida, we're asking you for the only verdict that is supported by the evidence and supported by the law. And that is a verdict of guilty. Thank you.
She nailed it. She did
All right, we're going to
such
take a
good
short
job.
10-minute break before we proceed with the defense closing.
She nailed it. Like, she hit every single point. And she went through the jury instructions about, like, okay, you have to have this and this and this to find him guilty of this. Well, here's your evidence.
All right, everyone may be seated. Court will be in recess until 3:10.
She nailed it. Wait. I forget I have that one now. This calls for just such an occasion. I am thoroughly impressed by her closing. She really did, like, it was hard to hear because it did take some of the hardest parts of this trial and throw them back up in our face. But man, did she nail that. That was incredible. She did an awesome job. So closings are supposed to last for 3 hours. They have 3 hours allotted for this. So this should take us right to the end of the day. And then I think they're starting deliberations in the morning. So we will do verdict eyebrows first thing in the morning. First thing in the morning. I don't know what the plan is for tomorrow yet. I need to look at some stuff. I don't know. There may, if we're not starting something new during Verdict Watch, I may use tomorrow to do a stream on Karen Reed. So homework is, if you haven't listened to the podcast yet, listen to it. It'll help. And then we'll use Verdict Watch to go over that, because I know a lot of people have listened to it. The podcast is doing great, which I appreciate. I appreciate all the support on that. But there are still some people who haven't listened today and don't know a whole lot about it. So this takes, like, I mean, this is one of the most complicated. I mean, who needs sleep, right? This case is nuts. So we may take tomorrow if there's nothing else that I have to look at schedules. If there's nothing else that's starting that we need to start, I may take tomorrow and do a Karen Reed podcast. Where do you listen to podcasts? Anywhere you get podcasts. Or if you want to listen to it on YouTube, it's uploaded on YouTube too, in the podcast playlist. The Conspiracy in Canton, I just put out I stayed up till 6 a.m. finishing it. But the fourth episode I put out this morning, so there's 3 of them. No, that I didn't come here to math. The fourth episode I put out this morning, so there's 3 of them. That makes a whole lot of sense. Let's try that again. I put out the 4th episode this morning, so there's 4 of them. That's what happens when you put out 4. There's 4, not 3. So that makes a lot of sense. But that hearing that we were watching earlier, of Turtle Boy, Aiden Carney, that hearing is, his charges are I got something in my eyeball. Sorry, y'all. His charges are intimidating witnesses, and it's the witnesses in this case. And I have charts on it on 13thjurorpodcast.com. The charts are about to get even more intense because as I'm getting through the investigation, some more people are going to be added into the mix. So it's a lot. But the podcast is also like Apple Podcast and Spotify and all those places. But it's under 13th Juror Podcast. And there are jury duty episodes on there too. They're like recaps of the trials, some of the trials that we've done. But this specifically these are the conspiracy in Canton episodes. Chris Carroll, we did a poll on that a minute ago. I ended it and it was, let's see, 42% said 2 to 4 hours. That was the majority. 27% said less than 2 hours. 21% said between 4 to 6, and 8% said more than 6. So the majority of you, vast majority, almost half, think that it'll be, what did it say, 2 to 4? Look at Angie Burr with my old lady bookmark. I see you, Angie Burr. Brandi, we're right here. I see you. Y'all are funny. I love our mods. Speaking of our mods, I've still got something in my eyeball. That's not speaking of the mods. Speaking of our mods, if you do, we have a command set up. If you do exclamation point, oh my gosh, what is happening to my eyeball? Something. If you do exclamation point tip, there it goes. Okay. Streamlabs will give you the command. If you would like to show our mods appreciation, you can donate a tip by going here. So if you love our mods the way that everybody loves our mods, you can click on that link and the tips go to the mods because they're amazing. I don't have on contacts. I don't wear contacts. I just have old lady glasses that I don't wear that often. I have to wear them sometimes though, because when I work so much, my eyes start getting blurry by the end of the week. I'll just do this. Oh my gosh. An old piece of previous verdict eyebrow. That's a good possibility, actually. All right. So somebody said that some of the videos in this were released. Oh my God. I think it's because I wore mascara. Didn't I have on mascara yesterday? I'm pretty sure I did. I put on mascara every once in a while. And then I didn't wash it off because I stayed up till 6 a.m. And I think it's like a mascara thing. Okay. I just need a pirate patch. Okay. Pirate patch. All right. What was I looking at? Oh, oh my gosh. Where do you see them? I was like, go wash your eye and stop touching it. I don't see them. If you have the links, you can send them to me. Let me wash out my eyeball. Let me go wash out my eyeball before it falls out or something. Okay. You can tell that I just got 3 hours of sleep and then got up and took Lucy out and then came in and just got started because I haven't actually looked at myself in a mirror today. And I didn't realize how bad my face is peeling from sunburn. And I just scared myself when I looked in the mirror. Like I don't think you can actually see it from this camera. But I assure you, my face is falling off. Piece by piece. Totally normal. So we're going to moisturize. Y'all can't see it. That's because it's far enough away. And I don't do that like really high. I don't have like a really high resolution camera. And I'm okay with that today. You know why? Because I've said it before, I look younger when I'm blurry. So we're going to leave it as is. We're going to leave it as is. But my face is falling off. So we're going to moisturize. Yeah. Like the equivalent, like the blurry camera is like the equivalent of, like, if I were to get yeah, my face is coming off. If I were to get like a high definition camera all of a sudden, if I were to get a high definition camera, it would be like the equivalent of like the lights coming on at the end of the night at the club, you know, when you're like, oh, is that what we're working with? All right. All right. Give me another shot and let's go. Just joking. I'm almost out of this moisturizer. But you know, it's okay. It's okay. We're just going to slather it on. Here we go. Face not falling off anymore for a moment. Anyway. Maybe I'll just start doing my morning routine with y'all. I'll be like, hey, y'all. And then I'll sit here and like put on my moisturizer and my old lady eye cream, which I don't wear, but I mean, I'm of a certain age. I should probably start like, like any of us who had the Playboy Bunny tattoo, like, or not tattooed sticker, like the Playboy Bunny sticker at the tanning bed. any of us who have that need to be putting on eye cream at this point. Like, that's just a life tip from Brandi. So there you go. You get that for free here. Life tips. Yes. Okay. It's still peeling. Yeah. Oh, I could be like one of those girls that like, aren't there like girls that put on makeup on TV and stuff, like on YouTube and stuff? I could be one of those. I mean, I don't have a whole lot of makeup and I don't really know how to put it on that great, but I could totally do it. Might not look good, but we could do it. Or, you know what though? I think verdict brows are about as far as I need to go. Beauty influencers. See, they even have a name. Beauty influencers. I don't know how much beauty would come out of me putting on my little bit of mascara that, I mean, I have like eyeliner and
The Honorable Harvard Coates presents.
something.
All right, good afternoon, everyone may be
I
seated.
have stuff.
All right, Ms. Murad, is the defense ready to proceed with its closing? All right, you may go ahead and bring the jurors in.
I'll be a terrible beauty influencer.
And Ms. Murad, when you're at the podium, make sure you use the mic if you walk away because it's a recording issue. I keep getting notes from recording that they can't hear you. Not you, but it was Ms. Coakley that was violating the rule.
Ooh, violated.
I'm going to make a suggestion for the clip-on mics. I don't know why we don't have them. That would solve it. Yeah. All right, all rise.
All rise. All right. I know we're going to be annoyed. Let's all take a deep breath and try to be non-violent.
All right, everyone may be seated. Ms. Murad, is the defense ready to make its closing? Yes. All right, you may proceed.
Here we go.
There is not one moment that I want you to think that this defense is about whether or not Ronan deserved the treatment that he got, because it is not. Or that the fact that he is vulnerable or had medical issues from early childhood is justification for what happened, because it is not. However, we are in a criminal courtroom, and what you have to determine is whether an act, a horrible act of parenting, a bad act of parenting, bad choices amount to a crime. And in this case, they do not. I told you at the beginning of this trial that Tim Ferriter had to make tough choices based on the experience that he had had with his son, Ronan. And I'll talk about that more in detail. But what I want to start with is sort of the bedrock of any criminal case, which is an understanding of what reasonable doubt is. There is an instruction that you will receive, and we'll talk about that later on in my closing argument.
Approach.
This is, they don't, normally they're not approaching during closings, but side bay. Side bay. We didn't even get into like We didn't get comfortable yet. Oops.
All right, objections overruled. You may proceed. And that's without prejudice to the state to address it in rebuttal.
So there's different ways to understand reasonable doubt. And I think that a helpful way to understand it is in terms of sort of the other standards that we have. So at the bottom here, you see reasonable suspicion. And that is like a super low standard. That's why it's on the bottom. So that is the standard that a police officer has to have just to sort of stop you on the street.
Sustained.
When we talk about reasonable doubt, it is in reference, right, to all the other standards, because beyond a reasonable doubt is the highest burden in our justice system. Normally, when we talk about a criminal case, it's different than, for example, a civil case where you are deciding whether or not something is done by the preponderance of the evidence. That's about 51%. The next level up from that is clear and convincing evidence. And that's the standard required for the government to take your children away.
All right, I'm going to instruct the jury that the court will provide and has provided you with the instruction on what reasonable doubt is. Attorneys can comment on the law that the court has provided, but anything else other than what the court has provided on the law, the attorneys cannot address, and you're to disregard that. So with that instruction, Ms. Murad, you may continue.
Thank you, Your Honor. Clear and convincing evidence is the standard by which the government can take your children away from you. And then higher than that, you have beyond a reasonable doubt, which is the highest burden in our justice system. And this distinction is important because when we talk about bad parenting or someone that shouldn't have their kids, there's a standard for that in the legal system. There's a system in place for that. What you are being asked to do is determine if something is a crime, if it rises to the level of reasonable doubt, such that a person whose liberty and freedom is at stake, as it is in any criminal case, should be found guilty of a crime. You are not being asked whether you condone of Tim Ferriter's actions. I put up an expert, Sheila Rappa, who says she does not condone of Tim Ferriter's actions. And I didn't do that not knowing what she was going to say. This case is about a different sort of location and time than what the state's talking about. There is no dispute that what Tim Ferriter did caused harm to Ronan Ferriter. My own expert got up and told you that.
Yeah.
The question before you is whether or not that was done with the appropriate intent to be considered a crime, whether or not those elements that the state mentioned are met. And so I want to talk about those in specific. Let's start with this. What are we actually on trial here for? The state mentioned a instruction towards the end of their closing argument regarding the things that happen in Arizona. And of course, the defense brought some of that in. It offers context. But the decision that you are making is whether or not Tim Ferriter committed a crime during about the 6-week period that he lived in Jupiter, Florida, between January 5th to January 28th. That's when the video goes up in the room. They move in.
Hold on. Sorry. Sorry. Hold on. I'm going to swap feeds because this one's being annoying.
A little bit before Christmas. That is what you are being asked to do. If you believe that Tim Ferriter committed a crime in Arizona based on the testimony, but you do not believe that the state has proven beyond a reasonable doubt that he did so in Florida, you must find him not guilty.
don't know how that's going to go.
I don't normally do this, but this is a lengthy closing, so I want to make sure that we talk about all the different sort of reasons why Tim is not guilty. I'm going to talk about these all in turn. They apply to different instructions. So rather than taking you through instruction to instruction, I want to focus on the reason for it being not guilty and the instruction that it applies to. So we'll go through these one by one. I first want to start by talking about sort of two ways that you can find Tim not guilty that are pretty related. First, he did not have criminal intent. This applies to every charge, right? Because criminal intent is something that is unique to a crime, as opposed to something in a civil case like negligent intent or something along those lines. Even if you find that the state has proven every element, including that criminal intent element, as to child abuse and aggravated child abuse, you can still find him not guilty because of the parental affirmative defense. Now, the way that that reads is that it is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from it. And this is the important part. If you find that the state proved beyond a reasonable doubt that the defendant was not a parent, that's not an issue here, or if you find that the state proved beyond a reasonable doubt that the defendant's physical discipline was not reasonable under the circumstances, you should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt. This is a little hard to understand, but this is a two-step process. First, the state has to prove every element of that aggravated child abuse or child abuse beyond a reasonable doubt. And then the second bit is they have to disprove this affirmative defense beyond a reasonable doubt. It is not the burden of the defense to prove to you that it was reasonable. It is the burden of the state to disprove to you that it was not. This trial is not about Ronan's diagnosis, but I understand that it's been something that we've talked about a great deal throughout the course of this case. It is, however, essential to understanding the sort of persistent behavior that Tim Ferriter experienced. And it allows you to understand how difficult it was for Tim Ferriter with Ronan's sort of ongoing behaviors. And I want to start with sort of the thing that's based most in science, which is Dr. Rappa talking about a neuropsychological exam. So that neuropsychological exam, as Dr. Rappa testified to, has multiple parts. And this is testing that the psychological and psychiatric community relies on routinely. And it allows us to have data about a person to explain how they are the way they are and why they are the way they are. This neuropsychological testing has multiple parts, and it includes something from Ronan himself and from an adult parent. Dr. Rappa explained that. And in this particular testing, there was no reason to believe that there were any sort of validity issues with the information that she received. She also said that even though the testing was from just a couple months after January 28th, that doesn't matter because it still is a test of executive functioning. What that testing revealed is that Ronan has clinically elevated levels as it relates to inhibition and emotional regulation. And what Dr. Rappa told us is that that means it explains this sort of persistent behavior that's not stopping, that becomes explosive. When Ronan has when Ronan feels angry or has sort of a strong emotional reaction, he's not able to control that in the way another person might be. He also has a lack of inhibition. And that's why when he has consequences, that's not something that he's entirely understanding. She said that it's very hard for someone who tested like Ronan did to be in control of themselves, and they have a lack of insight into their own behaviors. She also explained that this testing, right, goes back to early childhood. And that's not really in dispute. The state's own expert, Dr. Wade Meyer, said that he believes Ronan had an attachment type of disorder from the time that he lived in an orphanage. Again, there's no dispute that the Ferriter's actions exacerbated that, right? Dr. Rappa told us that. That's something that the defense is completely conceding. But both Wade Myers and Dr. Rappa say that this is something the Ferriters did not cause. It is from very early childhood neglect. And what we see and what the key is, and Dr. Rappa talked about this, Wade Myers had to concede to it, their behaviors before 2018, right? That's when we're talking about the timeline, we know that Pierce was born on February 28th of 2019. About a week prior to that, per Ronan's own testimony, a room was built in the garage in Arizona. Before that, while Tracy was pregnant with Pierce, a latch was put on his door in Arizona. So that has to be late 2018, early 2019. Prior to that time, Dr. Rappa testified about records that she reviewed from 2015 elementary school emails about ongoing and persistent behavior. And I asked her, because look, I understand, and the state made light of it, but stealing sprinkles or activities that are just considered childhood behaviors.
Sprinklegate.
It's very hard to distinguish what constitutes regular childhood behavior and what constitutes a disorder. And I asked Dr. Rappa that during her direct examination. And what she said is that it is the persistence of these behaviors, that despite there being consequences, despite there being boundaries, they continue and continue and continue. In cross-examination, Ronan admitted in great deal to his own behaviors, right? He admitted to harming other people. He admitted to offering his brother beer as an experiment. Sev de Borzati testified that a time that they were visiting an Airbnb in Sedona, Ronan was found with knives in his backpack. And the cross-examination on that was, well, did he threaten you with a knife? Did he use a knife? An 11-year-old shouldn't have knives in their backpack. Right? That's everyone's common sense. That as a young child, there are certain things, certain boundaries that you cannot cross because you're a kid. Ronan admitted to stealing from his own home, stealing from the parents of some of his friends. He admits to running away. He admitted to breaking into his tablet at his last school in Arizona and searching violent terms that concerned his parents. And that was the reason why he had to get his technology taken away. Kellen McCoy, who was a teacher of Ronan's, testified about an incident that he had with his sister. And in cross-examination, the state was asking Dr. Rappa about these sort of specific incidents, trying to minimize them or showing that, any one act is no big deal. And that's with any kid, right? Any one act that a child does out of being a kid or immaturity is never a big deal. But it's when it continues and doesn't stop over and over and over again, and when it escalates and when it becomes persistent, and when in this case you have a neuropsychological exam that supports that it becomes a disorder and something that is problematic to the child, to the parents, and to everybody that he's around. So Kellen McCoy testified about an incident where Ronan entered his sister's classroom, had her stand up, and humiliated her in front of the entire class. And during cross-examination, I recall Ms. Coakley saying something to Dr. Rappa, and Dr. Rappa was like, no, but it seems small, but that's not the case. And Ms. Coakley, you have to think about the steps it takes, right? To decide to go to an entirely different part of the school. That's what Ronan testified to. Pretend to be another person. Decide to point out your sister. Go to that classroom. Have the courage to come up with this entire story. that is something that gets to the level of being manipulative. And those are the concerns that were happening with Ronan throughout his life. And that's corroborated per Dr. Rappa prior to 2018 through Ronan's own deposition that she reviewed, through, I think she listed off 25 items or 26 items that she reviewed in coming to her opinion. Dr. Rappa also testified how when you have a lack of trust in a parent-child relationship, and I guess you can rely on your common sense for this, but when you have a kid, right, and they're growing up, you rely on trust. But we rely on that in any relationship that we have, that what we see is what we get, right? That what we expect when someone says, I'm going to do this or I'm not going to do this, that they actually follow through with that. And that relationship of trust is really important between a parent and a child. And when it is broken, Dr. Rappa said that the response that a parent has, the natural response, is to control, right? And we see that in our everyday lives. If you have a kid who's out, joyriding, you don't get the car, right? If you are someone who is fighting at school, you're going to be in a timeout. You see in this case that it is taken to an extreme, but it is also in response to an extreme. Riding who doesn't get their car stops. Most people's children stop when they say, you can't do this anymore. I'm going to take away your items. I'm going to put you in a timeout for a reasonable amount of time. I'm going to ask that you stop doing it. I'm going to ask that you not, hurt people at school. I keep getting emails from school about how your violence is becoming a problem. I need you to stop doing that. Eventually, kids stop. But Ronan didn't. It persisted over and over and over again for years. I want to show you a video of how Tim Ferriter responded to Ronan.
To the next step. So if you don't give a shit and you want to run away, see how that takes you. I'm not chasing you this time. See how it goes. If you want, should I put this ankle thing back on you? Because I kind of need to know where you're at, just so you don't hurt yourself. Because you have no fucking idea what's out there. You think you do. All 14-year-olds, 15-year-olds, these kids you're around, you might think you know what's going on in the world, but you don't quite know. Give it a try. Go ahead. But I gotta put the ankle bracelet on you. Because I'm responsible, and when I say I'm not giving up, I'm not quitting, you got me forever. So deal with that. But if you want to go throw your shit away, if you want to ruin your life, if you want to destroy this shit, I'm not going through this again and again and again. I'm not time for this shit. I got to deal with no one to the next step.
You can hear Tim Ferriter, and as Rappa said, in the worst tone ever sometimes, attempting to parent, right? And it is not perfect. I don't think any parents, would say that their parenting is perfect or even great in retrospect. But what he's telling him is, if you keep running away, I'm going to have to put a monitor on you. And of course, that sounds like an extreme thing to do. But what he tells him is, you're 14 years old. You don't know what's out there in the world. I have to keep you safe. Because if you keep running away on the street in the middle of the night or during the day, you're going to get hurt. Someone is going to harm you. And I am your parent, and I have to keep you safe. And it got to the point where they're talking about putting a monitor on him. That's how often this was happening. And no parent can allow their child to run on the street. Right? No parent can allow their child to be lost and not go find them. So he's telling him, you have to stop. He's telling him there is a big world out there and you don't know about it. And I know you think you do, kid, because you're smart, right? You're able to trick people. You're able to convince them that your name's Richard, I think came out in a video. But it is a big world out there. And there are people that could harm you. Tim Ferriter was trying to raise a child who could make it when he's older without having a criminal record, without having a million issues at school, graduating without getting kicked out, because we saw in the videos that he got kicked out of his last school in Arizona, and with positive social skills. If you are hiding knives and pretending to be people that you are not, and stealing money from your friend's parents, and bringing a scalpel to school, and getting into fights so often that your elementary school is sending emails in the 4th grade. When you are 6, 7, 8, 9, and 10, what are you going to be doing when you are 20 years old? And another point I want to make is this idea, when we talk about malice and intent, that this was something that Tim and Tracy Ferriter enjoyed, right? The benefit of your kids growing up, right? I have a bunch of friends with toddlers. They're just hyper vigilant all the time. They have to watch every minute of what that kid does because they're going to get hurt. They're going to put their hands in the socket. They're going to, right? That's that life. And as a parent gets older, that goes away a little bit. You can go out to dinner. You can grab a cup of coffee on a Sunday morning. Tracy Ferriter is watching Ronan's laptop, and for a reason, because he has broken into numerous school laptops and hacked into his entire school's IT system. And she says, I need you to do your homework so that I can see it on the camera. This is not fun for them. Waking up in the middle of the night to see if your kid stole an iPad from his sister is not enjoyable for a parent. Staying up in the middle of the night to make sure that your kid isn't doing something they're not supposed to do, keeping that kind of hypervigilance year after year after year for almost a decade is not something that a parent wishes to do. But they had to keep this type of monitoring on Ronan. And they did. And they did it without getting him arrested. They did it without sending him away. They did it without ending the adoption. There was always a reason to go through the videos, and there's a lot of them. I know you watched many of them. If you watch all the videos from inside that room, and I know we watched about 8 hours of it together, you can hear Tim telling Ronan every single time he's in trouble. You did the Chromebook again, right? You can't break into the Chromebook. There was a time, and Ronan admitted to it on cross-examination, where he went into the school, he went into a different teacher's classroom and said that he was evaluating the teacher with the school board. You can hear Tim say that. This idea that it is gratuitous, Ronan even says, discipline to you was always in response to something that you did. And Ronan said yes, whether that was a timeout, whether that was getting yelled at, whether that was getting in trouble, it was always in response to something. And I'll concede what Dr. Rappa said, that the tone was not appropriate and the strategy was not appropriate. That is not in dispute here. But to say that it wasn't reasonable to Tim Ferriter, who had a reason every time it was happening, that is inaccurate. When he talks about the AC, Ronan admitted in his cross-examination, it was right at the end of my cross-examination, I asked him about when he almost started an electrical fire at the home in Arizona, right? And he talked about how he was playing with the lights and tried to mess with the light switch. And he initially said, it wasn't going to be a fire because I would know how to fix that. And I said, that could really hurt somebody. And he said, yeah. So he's not allowed to touch electrical items or, equipment in his room. You can hear when Tim is talking about specifics. We talked about that. So I want to talk now about what you experienced during this trial versus what the Ferriters experienced over the course of time. So this trial, right, is really talking about not just what Ronan went through, but also a parenting relationship. Anytime something's happening to a kid by a parent, there's a relationship there, right? A parenting relationship that spans time. And what you saw was over about a week and a half. I know it feels like forever, but it was about a week and a half. And when you saw Ronan testify, it was about 2 hours. That is not what you are seeing in those videos that the state played. What you are seeing in the videos the state played is after year 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 of ongoing issues. And you are
Sustained.
And you are
Jury is instructed to disregard the last comments of counsel.
And what you are seeing is a family at their wit's end. There's no doubt about that. And I don't know a single parent, take away a child, take away all the variables, a child with behavioral issues or a diagnosis or even just, sort of benign behavioral issues. A parent and a 14-year-old or a 13-year-old, a preteen. I don't know a single parent who would want their worst couple months, their worst year with their relationship with their kid filmed on camera for everyone to see without any context, without any understanding of what was going on the years prior, without any understanding of who they are.
Sustained. Jury is instructed to disregard counsel's comment on her belief on the evidence.
We talked about whether or not this was in fact malicious punishment. And both Wade Myers and Dr. Rappa testified about that. And they testified in a different manner. Here's what I want to remind you about Wade Myers. The information that Wade Myers had was curated by the state and provided to him in the same way that we provided information to Dr. Rappa. But what he said is that he received 40 videos of the 21,000 that exist in evidence. He received 40 videos of the 8 hours that you watched of the state's evidence and the 3 hours that you watched of the 14-hour video that the defense put in evidence. That is not an entire picture of what happened in this family. In fact, if I remember correctly, when my colleague on cross-examination said, "Are you aware that there are 21,000 videos in this case?" Wade Myers' face visibly was like, "Oh, I didn't know that." So his opinions are based on a limited set of information, acknowledging that he may not have the entire picture of what was going on in this family. Dr. Rappa testified that she didn't believe that this was malicious. And you can evaluate the credibility of any expert the way that you want. Dr. Rappa, compared to Wade Myers, testified on cross-examination in a manner that was very honest and not in any way
Sustained.
And not
It'll be up to the jury to determine credibility.
she didn't fight with the state in the way that Wade Myers did, the way that Wade Myers did with the defense. And she admitted to everything as it relates to the harm caused, the fact that this is an inappropriate way to handle a child. That is something that Dr. Rappa said was absolutely true, right? So when she's looking at all this information, she's telling you that the reason it's not malicious is because this was a poor effort at parenting a child that has issues that these parents did not understand and that providers did not give them. She said that it's common in mental health types of situations for families, parents, to get really, really frustrated because Ronan's on clonidine. That's not working. This isn't working for sleep. They're getting advice about limit setting. That's not working. They're getting advice about take him to therapy sometimes. The one-on-one therapy that he had with family counseling wasn't working. It's not changing the behavior in the school. And that's happening year after year after year. And Dr. Rappa said that it's really common in her field, and she's worked with a lot of children who have similar issues to Ronan and a lot of parents in these types of situations as well. And it's very normal to feel extremely frustrated with the mental health system, right? Because you keep doing stuff, you keep taking them to the appointments, and nothing is helping.
They didn't keep
And
taking
not
him.
one of these doctors recommended inpatient treatment. Not one of these doctors recommended what Dr. Rappa said would be appropriate treatments for reactive attachment disorder. So they're following the advice that they are receiving, and nothing is helping. When I was talking to Ronan in cross-examination, he had to be reminded of this, but he said that he was going in Arizona to appointments about once a week. So many that he didn't remember who the providers were. So this idea that they didn't try is not true. Ronan himself has said that he was going and seeing people once a week. Both experts testified that there were emails between the schools and the parents talking about Ronan's behavior, trying to figure out how to deal with it. Miss McCoy, the former teacher, testified that after the incident with Nola in the classroom, Tim came with Ronan separately and Tracy went with in order to try and talk to the teacher and figure out what was going on. The idea that these parents were not involved and not trying is distant from the facts. There were also non-medical efforts, and I know that it sounds silly, the meditation, but this is a family that from when this child was a kid was like, okay, what are the non-medical options that we can try? What can we do to burn off his energy? What if we don't give him sugar? Maybe that'll help. What if we don't, put him in karate, jujitsu, put him in these activities like track, what he did in Arizona. He did chess club. In one of the videos, you can hear Tim say, Ronan didn't get it because he stole an iPod or an iTouch, but he said, I was going to get you that gaming computer that you really like because this kid is really good at IT, at gaming, at that kind of stuff. So they're trying to get him into activities that they think will help his behavior because none of the medical interventions were doing it. The state mentioned in their closing argument that after 2019, there was no evidence of any medical treatment. That's not true. When the state was asking Dr. Rappa the same thing, she said, I think there were some appointments with Kenny Miller, and when they started school in Florida right before Christmas of 2021, there's a record that shows that they went to a pediatrician like you're supposed to go to, and that they asked for a referral for a psychiatrist, right? And you can use your common sense here. That's not something that happens overnight in any doctor type of situation. You have to get a referral for psychiatric care. I want to go now to points 3 and 4 that I had in that sort of initial slide or roadmap. So I want to talk about with you Ronan's sort of life at home. And this goes to the elements that this was not torture, which goes to the aggravated child abuse, and that it was not malicious punishment, which also applies to the aggravated child abuse. Where Ronan lived, whether it is appealing or not, is a room. And I want to show you this. When Ronan moved into his room, this is what it looked like. And you can see the girls' rooms. The photos aren't great, but this is not in size that different from what the girls' rooms are. It's an 8x8, which is about the size of a small room. He has his toys, he has his Legos, he has everything on the walls. This is how the room started. The room itself for Ronan was not punishment. It was his room. And if you look at the videos in State's Exhibit, I think it was 16, you can see Ronan doing things in his room that have nothing to do with being in trouble. He is, there's one video where he's FaceTiming a friend and showing them his room to show kind of where he lived. He's playing games. He's playing with Legos. There's a video in there where Pierce comes in and tries to play Legos with him, and he says, no, I want to play alone right now. Ronan also testified that that room was not always locked. It was locked in the evenings when he was asleep, and it was locked if he was in a timeout. The state also mentioned that, this narrative that this was a secret. The Ferriters hired a contractor to build this room.
And told him it was an office.
It was not privately done by them. They also had the garage door open for much of the videos that you watched yesterday, where Ronan was coming in and out. And so this is not some sort of secret. The teachers knew. There's emails back and forth about Ronan's behavioral issues. The fact that Ronan had restrictions that other kids did not have or that his siblings did not have was not a secret.
Sustained.
The state's expert characterized, and the state's been characterizing this room as a cell or a box. And I showed you this photo. It's a room with a desk and a bed and toys, and it has stuff on the walls until Ronan took them out or they were taken away from him because he was in trouble. I want to talk to you about the bucket that was placed in the room. Tim says to Ronan in one of the videos that you watched it was one of the videos that the state presented. So it was a couple days ago. It was last week. I don't want you to use it. Call us so that you're not using it. Throughout that 6-week period of time, it is used 2 to 3 times in total. What it is not is deprivation of a bathroom. It is a terrible solution to wanting to make sure that Ronan in the middle of the night cannot get out of his room. Because as you heard Tim Ferriter say in the videos, he is running away. So much so that he needs to place a monitor on him so that he is not running away in the middle of the night, telling people that he's someone he's not, and putting himself in danger. You can see in the videos of the sort of timeouts that Ronan's in, and you can always tell because they're always like, do you still have a bad attitude? Or you don't get your Chromebook for this. You can tell in the videos what's going on that day with the family. And they come in every 15 to 30 minutes, and you can see those in the videos, and they say, do you still have a bad attitude? There's one video where Tim actually lets Ronan out of the timeout because he says, you know what, I feel, I'm not in trouble anymore. So this is on January 23rd at 7:10 p.m.
Okay, Sean. So did you get that much? You checked your pockets? No. But don't get that into that because you run that. Okay. What's the nail there? What's the leg down there? Not to lie down. It's down here.
So throughout the videos, you'll see this happen, that they're checking in on him. They're saying, okay, are you still going to act out if we let you out of the room? And that happens to children all the time when they're in a timeout, that they have to act appropriately. They have to come out without a bad attitude. And it's never because, as the state represented, that it's just a bad attitude. If you go through the videos, you will see that there are exact incidents: stealing a Chromebook, pretending to be somebody you're not, causing an issue at school that it's about. I want to talk a little bit about the actual time that Ronan spent in his room. It's the state's duty to present you with evidence so you can determine what the truth is in any given case. And we talked about in jury selection how the defense can sit there the whole time and not do anything, right? We did not do that. but it's not the burden on the defense. We don't have to cross-examine anybody. We don't have to put on any evidence. We don't have to put on any witnesses. If that had happened, you would have left the long weekend only with the videos that the state presented you, which was 8 hours of Ronan only in his room and only getting in trouble. It was not until the defense put on a case that any context was provided to what was going on in this home in a daily basis. It is their obligation to present you with all the facts or the relevant facts.
Sustained.
It is their obligation to present you with.
The objection is sustained. It's not the state's burden to present with all the facts. It's the state's burden to present all the relevant facts material to the case that's being decided by the jury. You may continue, Ms. Murad.
And what is material in this case is all of the evidence of what was happening on a day-by-day type of basis. And what the state said in their closing is that, yes, of course, negate and tiki torches, he wasn't acting like that around his dad. Because that is not a constant state in this family. It is not a constant state for Ronan, and it is not a constant state for Tim Ferriter. There are other things that happen during the day. And we went through the videos and tried to provide, let me see. Sort of a breakdown of the time that Ronan actually spent sleeping in his room and not in his room. And what you can see is that 43% of the time is spent sleeping. There's one time that they come in the middle of the night, you can see it in the videos, and wake him up to look at his room, and that's on a day that there was a stolen eye touch. I'll show you that. And there are 2 to 3 times that he wakes up to use the bathroom. Other than that, he spends the vast majority sleeping at night.
To use the bucket.
The time that he spends in his room, not asleep, changes over time, depending on if he's in trouble, if he's in a timeout, but that's about a quarter of his day. And the rest of it, he spends at school, at home, playing with his friends, doing chess club, and all the other things that kids do. And so I want to go back to this video that the state presented of him being locked out. So the state alleged that Ronan was locked out of his home in Jupiter, and they showed you one video. That is, in fact, not the case. And so the first video is what the state admitted into evidence from January 22nd at 12:19 p.m. admitted is Defense Exhibit 18, and that's available for you. You'll get all the exhibits at the end of the day. The other videos that give context to this one. Because what was actually happening is that Ronan was gardening with his dad from about 9:30 in the morning.
Sustained.
It's in the videos that you can see that are admitted as Defense Exhibit 18. And his father actually brings him water in those videos that are admitted in evidence, and you can see for yourself.
Can we have counsel approach, please?
I'm having the little thing keeps popping up again. So every once in a while it's freezing for me, and trying to, I'm about to call again and find out when they're going to be done working on it because it's driving me crazy. How are we feeling? How are we feeling about this attorney? Not a fan. Oops. Not a fan. But, you know, whatever. Don't touch anything. Yeah, I'm every time everything starts to freeze, I'm like, may not do anything. I drove them nuts yesterday, calling over and over, trying to find out when they were going to be done working on it. But it's better today than it was yesterday. So hopefully they're almost done. But this lady's frustrating. It's hard to hear the victim blaming, especially when it's a kid, you know? Chunk of bacon. That's my favorite insult ever. I wouldn't subscribe to her YouTube channel if she had one. That's my favorite. That's my favorite insult ever. From now on, when people in like my real life are annoying me, I'm gonna be like, you know what? I'm unsubscribing to you. That's funny. She is exhausting. What case am I doing next? Well,
All right, Ms. Murad, you may continue.
thanks, Judge.
I'm now going to play one of the videos that the defense put in. Under Defense Exhibit 18, there's 3 that offer context to what's going on here. And you can see that several minutes later, several minutes later, Ronan enters through the back door. And again, this is why this is important. You have to have the full picture of this parent-child relationship in order to make any determination about what the parent-child relationship is. And it does not justify the actions that Tim Ferriter took. That was those were bad choices that he made, and we are not disputing that they were harmful to Ronan. What it does not prove is all the elements that the state has to prove, particularly as it relates in what we're talking about now to whether or not there's intent, whether or not it was malicious punishment, whether or not it was torture, whether that's what it constituted. The defense admitted a 14-hour video. We did not show you the entire video because you watched many, many hours of the state's video. However, the entire 14 hours is in evidence. And what we tried to do is provide, as much as we could, different days and different sort of experiences that Ronan was having. And it's not just relevant to show the context. It's also relevant to show what's actually true about what happened. This idea that Ronan didn't have the ability to eat snacks when he wanted to. One of the videos that we watched, he was watching football and there was a bag of popcorn on the dining room table, and he grabs the entire bag and starts to eat it. This is after the state's expert, Wade Myers, who relied on only 40 of the 21,000 videos, said that this child, and that's part of his opinion, right? Why it's solitary confinement, why he believed it was torture, why he believed it was malicious. He is relying on facts that are not the whole truth. And so, of course, if you only watch those videos or the 40 that the state sent him, you're going to think, as you probably did after watching 8 hours of video, that the entire life of this child is in this room. And that is not true. You saw him playing outside. Prior to January 5th, you see him frequently outside. I know it looks like Tim Ferriter only watches football for a living, but it was December 31st and January 1st. And so there were a ton of football games coming on. If you go later, I think we showed you January 5th, 7th, 9th. You can see them walking outside as a family, playing in the cul-de-sac, playing with Pierce, who clearly really loves Ronan. Ronan fixing up a scooter that he had. That is also the life of this child. Fiona testified, and so did Ronan. This is a busy family. I think in every video you saw Tracy running around in the back from, place to place, grabbing Pierce. But you have 3 kids that are around 13, 14 years old, all with their own activities, right? Nola has softball, Fiona has band, Ronan at the time had chess club. And so all these people are running around. They are not eating meals at the same time. They are not sitting around their kitchen table, excluding Ronan, who's in his room. And the videos will corroborate that, should you wish to watch 14 hours of video. That is what you will see, that people are running around getting snacks. Tracy, at one point, we didn't end up watching this in the 3 hours that we presented, makes cookies for everybody, and Ronan partakes in that. You see him in the earlier videos, I think it was December 29th, coming back with little styrofoam boxes of leftovers. Wade Myers and the state are alleging that he had no control over his movement, where he went. And yes, at night, he was in the room with a lock on the door so that he could not get out, so that he could not run away or harm himself or do something around the house or get knives like he did before. That's at night. During the day, he went to school. He was with his family. And there were days that he was in trouble, and we're going to talk about that. And he would be in his room as a timeout because he was not allowed to engage with everybody when he's in trouble, when he gets in trouble at school. The videos, again, it's 14 hours, do get tedious. But the reason it's important is that there are extended periods of time every single day that you see Ronan have full control over his movement, what he's eating, where he's going, walking around the house, playing outside, doing yard work sometimes. We talked about that, chores like everybody else had in the family. That is a family. That is the life of a child. There are days when you are doing chores that you do not want to do. And there are days that you have to help your dad out with the yard and the tiki torches. And there are days you are chilling on the couch with your dad, watching football. There are days where you are in trouble, in really big trouble, and you are crying in your room because you are so frustrated that either you're in trouble with your parents or you did something that you didn't intend on doing. And it is the life of a parent that sometimes you need help with the random stuff that your wife's making you do around the house. You have your son help you out, that you're running around dropping the kids off so you don't have time for everybody to sit down and have a meal or have a breakfast that is exactly the same or have or you know, make everybody a different breakfast every day. You're dealing with the stuff that your kid did at school. You're getting emails back and forth and having to deal with that. Go to the school, drop the other kid off, and go to work, pay your bills. That is the life of a parent. And sometimes you get frustrated with your kids and you do things that you regret. That is the life of a parent. And that is the life of a child. And sometimes kids and their parents are on exactly the same page, and it is a really good day. And sometimes you couldn't be on further off planets and you are mad at each other. And you say things you regret and you do things that you regret. But that does not make you a criminal.
Overruled.
I want to talk a little bit more specifically about the videos that you saw and what happened during the course of this 6 weeks. So a really important day is January 5th. And you can see from the videos that January 5th was the first day of school. And I want to give you context for what happened prior to January 5th. There's a video in which you can hear Tim getting really mad at Ronan and saying, you just got kicked out of basis. We got to start this school off right. We cannot be in a situation where you are getting kicked out again from school after school. And Ronan admitted on cross-examination that at basis, he did in fact jailbreak a school laptop, right? That does not belong to him or his parents, and did violent searches on it that were very concerning to his parents, and that they responded to that because as a 14-year-old child, you should not be doing searches like that. And on January 5th in the evening, Ronan is asked, did he do a search after he jailbroke a tablet? And was there something concerning to mom and dad? So we talked about this. Now, when we get to January 5th, the state presented some of this video. I would like to present all of it. And the state represented that the reason Ronan was in trouble on January 5th was for something as minor as stealing candy. That is not true, and that is not what the videos and the state's own evidence show. So I'm going to go through these one by one. I also want to point out that at this time on January 5th, they moved probably, week 2 before, based on the records. He still has everything in his room. He has his toys, he has his bed, he has his computer, he has all the posters that he likes. This is a time before he got in trouble, and it's a real turning point in this 6-week period.
You gonna play a little bit, or are you tired? You can play a little bit.
So you can see there that there is something going on in this corner that Ronan is doing.
He's
and
at
you'll
1 hour.
see more context as we go through that he had something he was not supposed to have. And he was hiding it right and wouldn't be able to check.
she's got another half hour, and then prosecution will go again. They had like exactly enough time to get all of the closings in today.
It's been 84 years.
You gonna play a little bit, or you're tired? Yeah, a little bit.
Now you'll see Ronan rearranging the entire desk and bed arrangement.
Got a little less than half an hour left.
I don't know, you have to see.
So at this point, he's moved his desk, right? And we saw in the other videos that they want the Chromebook. It was specifically, you can see Tim when he puts it up on the 5th, that they want the Chromebook to point towards the table. You can see him almost adjust it in that video. And I understand why in any other circumstance that may seem like very unreasonable supervision for a child. A kid should be able to use their devices how they want. However, when a 14-year-old is using their devices in a manner that is destroying school property, that is breaking into the school's IT system, that is doing searches that the parents do not approve of and that are unsafe, then a parent like Tim Ferriter decides, I have to remove your technology. And when you use it, you have to be monitored. Because as Ronan testified, this is not the first time he jailbroke a school laptop. It happened at his school in Jupiter. It happened at his school in Basis. He broke into the IT system at Immaculate Heart. This is a consistent pattern, and you can't break school property, right? Someone has to pay for that. Someone has to answer for that. And what never happened is that Tim Ferriter called the police or told the school, take my kid to jail for committing a crime. He said, I'm going to handle it myself. And though he handled it very poorly, as you'll see here, there was a reason for everything that he did. And so we're going to watch these videos, which were showcased by the state, so that you can see what they presented and then previously what was the context to what happened. Because as you'll see, it was not about stealing candy. It was about stealing an iTouch that did not belong to him.
Can I tell her something? Stand up. Tell me something? Don't tell me what. This is your one chance. Don't look at me like an asshole. You want to tell me something or not? I have a nightmare. Yeah. What the fuck is wrong with you?
You're feeling
Fucking
like
disappointing.
chocolate, and everything. You got so much stuff in your
You're
room.
fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school. And you're gonna be in this room. You're this close. Because I can't trust shit you do. But put the ankle bracelet back on, and then you can try to fucking run away if you want and do all the bullshit you do. But I'm gonna lock your ass down. Those are from my foot. Give me a fucking break. I'm sick of the bullshit. You're a big boy, you're gonna steal, you're gonna talk to the police, I'm gonna give you a fucking real deal. Okay? You're gonna steal from our fucking house? Again? Give me a fucking break. What other shit do you got in here? Because you're gonna lose it all in about 2 seconds. Lose every fucking thing. All this shit. I told you not to unplug that fucking thing, right? Yeah. You listen to me? Yeah. Bullshit, you
to plug this in, and then you're just a liar, Ronan. Just keep lying. You lied earlier when I asked you. You can't.
You're a big boy, you're gonna steal, you're gonna talk to.
Throughout their closing argument, the state, when showing you some of these videos and Tim's own statement, says that's malice, that's anger. This is how maliciously is defined. Wrongfully, intentionally, and without legal justification or excuse. It later says that the primary purpose of the acts was to cause the victim unjustifiable pain or injury. In every video that you see in this case, you will see that there was a reason for what Tim Ferriter did. And you will also see, in light of the context in this case, that moment that you saw, those 6 weeks, are a pinnacle of frustration, right? That tone, that frustration that you are hearing. Is after years of continuous efforts. I want to talk next about the child neglect instruction. In the instruction, one of the things that the state has to prove is that the parent did not provide care, supervision, and services necessary to maintain Ronan's physical or mental health. The state talked about the child neglect instruction briefly. In this particular case, we can see, so for example, the state said that there is no record of any treatment after 2019. As we discussed, that's not the case, and that's not what Dr. Rappa testified to. In fact, Dr. Rappa relied on medical records from about 2019 to 2021, where Ronan was being taken routinely to the doctor. Dr. Stuart Graham testified that there's no evidence of malnourishment. And the reason we felt that was important as the defense is because of this ongoing discussion about control over food, which, as you saw from the videos, is not consistent with the facts. When he was in trouble, he would be given food in his room. He even said, when we talked about the meals, he said he got the peanut butter and bananas on bread, and he said he was a pescatarian. And so I said, so you were given a meal for a pescatarian? And he said, yes. When you watch the videos, you'll see that the family is eating, Ronan is out with them, and there are times when he's in trouble and he has to eat in his room. You'll also see that the other kids are not eating around the table without Ronan. Everyone's grabbing and going and running like any family. We talked about his ability to manipulate the air conditioning and how that's not neglect, that there was a safety concern there after he almost started the electrical fire. He went to the doctor routinely. So now we need to talk about whether or not there was a valid legal reason to what happened. And this applies very specifically to the unlawful caging element of aggravated child abuse and to false imprisonment. So under the law for false imprisonment.
Okay, real quick, it wasn't about a safety issue with the air conditioner, because the dad even said, oh, you're a tough guy. It doesn't matter if you're hot, you're a tough guy.
I want to read it to you exactly.
Please.
States as follows. That you forcibly, secretly, or by threat confine, imprison, or restrain Ronan against his will, and that you had no lawful authority to do so. parents do have lawful authority to contain their children.
Oh,
Sustained.
Oh.
The jury will rely on the court statement of the law and not counsel's statement.
When a parent has a child, right, a really young child who has to, we're talking about a toddler here, and I don't mean that in a derogatory way. When you have a child who can't be trusted, right, they are contained. And as a parent, you do have a right to put your child in a timeout. You don't have a right for it to rise to the level of abuse, and I'm not trying to suggest that at all. What I am saying is that a parent can make a decision that the safety of that child, and in this particular case, Ronan is running away, as you saw from Tim, who was saying, "You've got me forever, but you have to stop. Because if you keep running away and you keep lying to people about who you are, you're going to get hurt in this world." You have the ability, and that's why it's lawful authority, to say, you cannot leave your room.
Sustained.
As to the unlawful caging, that parental affirmative defense applies to the entirety of aggravated child abuse. So when we're talking about whether a parent's actions...
I'm going to overrule that based on prior conferences that the court had with both sides on jury instructions.
applies to the entirety of aggravated child abuse, that parental affirmative defense. And so the decision that you're making is not, would I have done that in Tim's situation, but whether Tim felt it was reasonable to do that in light of the unique circumstances
Sustained.
that he was facing as a parent.
All right, jury's instructed to disregard the last comment of counsel. You may continue, Ms. Moran.
That reasonableness element that you are determining, right, as to what a reasonable parent would do, it is under these circumstances. And the circumstances that Tim Ferriter was facing are different than the circumstances of another person who may be in that chair. The circumstances that Tim Ferriter was facing are important in your determination. Because he had a child who, as Dr. Rappa testified, had no impulse control, wasn't stopping, and who by his own testimony was breaking the rules routinely despite knowing that there were boundaries. And these are not just minor incidents. The state can pinpoint a few minor incidents, but the reality is that their own expert knows that the child had an attachment disorder. That expert testified that there were no suspensions in the record. That's not true, and Dr. Rappa explained that. Ronan admitted to that in his own deposition, which Dr. Rappa relied on. This idea that the behavior was so minimal that it didn't matter couldn't be further from the truth. There are doctor's visits as early as 2017, when Ronan was probably 8 years old, documenting, as Dr. Rappa testified to, uncontrollable tantrums that are consistent with having an attachment disorder, of harming other kids at school. There are school records that Dr. Rappa testified to saying this is getting dangerous, and it is not stopping, right? That's what she said. It's that lack of predictability and the persistence that is really important in understanding the circumstances that Tim Ferriter had. Because those are the only two things we can rely on, right? Is that when you ask someone to stop doing something, they'll stop. And that when you, and of course it's a little different with a child, you give them a little bit more room to grow, but there comes a point where that stops too, where it's becoming dangerous, where they're not allowed to run out of the house in the middle of the night, where they're not allowed to steal knives from a location where the knives do not belong to them. The fact that they did not utilize the knife doesn't matter for a 10-year-old. You shouldn't have knives. The fact that you are doing searches on your computer for violent things, you're not allowed to have access to computers if you do that. So those circumstances are unique to Tim Ferriter. And that lack of predictability Dr. Rappa talked about, right? We expect people to act in a certain way. And the thing about that impulse control and lack of emotional regulation is that there is no expectation with Ronan. There are good days and there are bad days. And you see that in the video. There are days where he's hanging out and nothing's happening. And there are days where he is so frustrated, he is screaming in his room. Those good days and bad days are consistent based on what Dr. Rappa and Wade Myers testified about with someone with that attachment issue or complex PTSD. That both admit the Ferriters didn't cause, and behaviors and issues consistent prior to 2018. After I am done, the state has the opportunity to have a rebuttal. I do not have that opportunity. This is the last time that I get to talk to you. And so I want to discuss again reasonable doubt. Before I do that, I want to talk a little bit about, the jury credibility instruction. You heard testimony from Fiona, and the state talked about how it was consistent with what Ronan said. What you will recall about my colleague's cross-examination of Fiona and also mine of Ronan is that there were things that were either not remembered or misremembered. And I don't think that these kids are lying. I think that Fiona is a teenager who has her own life going on and doesn't always remember and doesn't know everything that happened with Ronan, right? Her parents are not telling her every single thing. Mr. Waugh had asked her about specific acts that had happened, and she didn't know about them. She also said that he never went to a marching band practice, and we were permitted to admit this exhibit showing Ronan at her marching band practice, that he was never permitted to do homework in the house. And there he is doing homework with her in the house. And the state can say all they want that, oh, these, minimal incidents, they don't minimize this, that, or the other, but it does challenge the credibility of the witnesses. Because Ronan initially said that he never got food, that he occasionally was fed in Florida. You can see on the videos that's not the case. You can also see that when I questioned him, I went up to him with his deposition and said, look, when you were in a deposition and sworn under oath, you said you got every meal. And he said, that's right, I agree. So at the end of the day, these are children. And the best evidence is going to be the videos that you see. And I encourage you to watch that 14-hour video as best you can during the course of this. So now let's talk about reasonable doubt. So the instruction that you will get and the judge has read to you, but I want to highlight a portion of it, is this. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after considering carefully, comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Reasonable doubt is one of the earliest terms that we learn about in our civic education, our legislature, and here's why it's so important. This is a decision that is probably more permanent than every important decision you have made in your life.
She's got 10 minutes.
Go back there as jurors. You will come to a verdict, and that will be it. If you get married, you can decide to have a divorce.
Sustained.
This decision is one that you cannot change, unlike many decisions in your regular life. And that is why we have an instruction that says if you waver and vacillate, if you think, you know what, he shouldn't have done that, I think he might be guilty, but then in another minute you're like, there was a reason for this, I think that affirmative defense applies, you must find him not guilty. If you think he might be guilty, you must find him not guilty. If you think he could be guilty, you must find him not guilty. And the one thing that I'm telling you is you do not have to like Tim Ferriter, and you do not have to like what he did, because what he did was wrong. And he will have to live with that for the rest of his life. When Ronan testified, he said, Tim and Tracy were just acting out a frantic surprise of my emotions. And he said, forgive them and move on.
Sustained.
That is his testimony. And so when you are back there deliberating, understand that Tim Ferriter made bad choices, and you do not have to agree with them. But whether or not what he did amounts to a crime under the law is a different question altogether. And it is one that the state has not proven. I'm asking that you find him not guilty.
Thank you, Ms. Murad. Rebuttal?
She had like 8 minutes left or something like that.
Hey, Ms. Murad, just hand Ms. Black the microphone. Thank you. You may begin, Ms. Black.
Oh, I'm sorry. I thought I did.
Are you going to be using the screen?
I'm not.
All right, you can go ahead and cut it off then. All right, thank you.
Defense just got up here and told you that the horrible act of parenting is not a crime. But in this case, it is a crime. Because it's about what a reasonable parent would or would not do. Because what Tim Ferriter did was not reasonable. Now, defense got up here and talked about the horrible things that Ronan Ferriter did, the dangerous things that he did, the reasons why he had to be locked up. But you have to remind yourself, these are things that he did when he was 11 years old. He is a child. He is in elementary school. Kids in elementary school will get in fights. Sometimes they'll go ahead, make jokes. He decided to go into his sister's classroom and tell the class that she was lying, made her cry. He decided to get into a fight with another child. But none of these actions amount to the treatment that he got from the defendant. Because you have to put it into perspective. These things happened when he was 11, 10. Yet when he's 14 in Jupiter, Florida, in that box, that's why. Because of the things that he did when he was 11. They talk about how the behavior was escalating. But what behavior? The lying about stealing chocolate? The bad attitude that he had when his father put his hands on him, threw him on the bed? The bad attitude that he had when he was throwing his Legos around, taking off his posters because he didn't know how to handle the trauma that the defendant caused him. That was the bad attitude that he had. Now, defense also spoke about how Dr. Rappa had records of after the fact, how in 2022 there was a neuropsychological done. But you also have to remember that this evaluation was done after the defendant had been arrested for these charges. You also get to take into consideration the fact that it is a self-reporting evaluation. That the things that Ms. Ferriter told the doctor, those are the things that she wanted to tell the doctor.
Overruled. Overruled.
Dr. Rappa also talked about that in this evaluation that there were changes, there were certain levels in his inhibition, his emotions. But she also testified that this is because of the way that the defendant treated him. She got up there on the stand and said that this is not malicious. This is just how they had to deal with it. This was the end result for them, not malicious. Yet, she never spoke to the defendant. She never interviewed him. She never got.
I'm sorry? Overruled.
She never got the chance to find out why. And for her, it was pure speculation as to why. The biggest thing here is the criminal intent. Now, we already talked about this in jury selection. What does intent mean? A lot of the jurors would say words, actions, past behavior. And that's what the state has presented you with. We have presented you with the defendant's actions, his words, his behavior towards Ronan. Because it's the intent to do these things. Under the aggravated child abuse statute, under the instruction, an and. It's an or. That he was unlawfully caged, or that he was maliciously punished, or that he was unlawfully and willfully tortured. And we have presented evidence of all three. You might go back up there and say, you know what, I don't think that they proved that he maliciously punished him. But he did unlawfully cage him. And that's still guilty of aggravated child abuse. There is also, the defense also brought up the fact that Ronan was explosive, that he was violent. But there was no evidence of that during that 6-week period in Jupiter, Florida. If you see the videos in both the state's videos, in the defense videos, he was docile. He seemed nervous around his parents. At one point in the defense videos, he's standing next to the couch while his father's watching TV. He doesn't know whether he should sit down or not. He doesn't know how the defendant's going to react.
Sustain.
But eventually, you will see that he sits there and he'll look at the father's reaction.
Sustain. I mean, excuse me, overruled on that.
You will also see in some of the videos how he acts in the room, that he's withdrawn, that he doesn't have that stimulation. I know defense got up here and showed you January 5th. That was the big picture. He had his Legos, he had his desk, he had his bed, he had everything. But throughout each day, there's less and less and less. They try to say that this was the result of a timeout. But we all know that from Dr. Myers, a timeout is not a long duration of time. If they wanted to call a timeout, it's a timeout from January 5th, 2022 to January 28th, 2022. Again, not reasonable. Defense also brought up that this was a natural response to control the child. That if a child stole a car, what do? You take the keys away, you take the car away. And that it's not taken to the extreme. But making a child go to the bathroom in a bucket, that is taking it to the extreme. They said that they wanted to lock the door at night because they were scared of him running away, scared of him causing harm to himself, scared of all these things would happen to him. But there was no evidence of that. He couldn't even leave in the middle of the night to use the bathroom. He had to be degraded and dehumanized and use that bucket. Not only that, but you saw in multiple videos that the animals had the freedom to go around the house. Yet he was the one that was locked in that box.
Overruled. Jury can rely on their own understanding of the evidence that was presented and published to you.
In reference to the violence that the defense was talking about, there was only 2 times that was brought up. And that was in Arizona, in which the defendant's not being charged with. We're specifically talking about the time frame in December of 2021 to January of 2022. They also brought up that they had to keep Ronan in this box because it was this way. That's what they had to do. They had no other option. They had no other choice. This is what had to be done in order to protect them. But you know what else could have been done? The medicine, the therapy, that could have been done. Both experts testified that there were only a handful of times that Ronan had gone to a mental health professional. One of the experts testified that there were about 2 or 3 30-minute sessions. Is it reasonable to think that in 2 30-minute sessions, the problem is going to be solved? No. But the defendant, the solution to that is putting that kid in that box. Not trying to find other providers, not trying to find
Overruled.
different medications that may have worked for him. But no, that was their solution. Both experts also testified that this was not the proper solution. This is not what you do when you have a child with these issues. This is not what you do when you have a child that just wants to be loved, that wants to be part of that family.
Sustain.
She
Move
rolled
on.
her eyes.
Jury is instructed to disregard the last comment of counsel. You may continue.
There was
Ms. Black.
also a comment about Dr. Myers not watching all 21,000 videos. Yet Dr. Rappa did not watch all 21,000 videos either. And again, they went to some doctors and then it stopped. They didn't follow the advice. And again, no doctor told them.
Overruled as to that. Again, the jury is instructed to rely on your own recollection of the evidence in any determination you make.
The biggest thing here is that the crime occurred in the only space that Ronan had known for long periods of time. The state never made any allegations that he was in there 24/7. The state never said that he had never left his room. He did. But you have to also look at the fact that the only time he left his room was when there was a parent around. When they told him, you're allowed to come out. When they told him and they would stand there and follow him out. Those were the only times he was allowed from the room. There was also times that he did not control the light. It was the defendant who would control the light, whether it was on during the day, whether it was off during the day, whether it was on at night. He also controlled the air conditioner. You heard testimony in the videos that the defendant did not want him touching that air conditioner. Even at points where Ronan says it's too hot, still told them, do not touch it. I know defense got up here and they started talking about the affirmative defense to the aggravated child abuse and to the lesser of the child abuse. There is no affirmative defense here because what the defendant did was not reasonable. It was not reasonable to lock him in a box. It was not reasonable to leave him in the dark. It was not reasonable to take the light away from him. It was not reasonable to leave him in the room with no air conditioning. It was not reasonable to make him pee in a bucket. There was no legal justification for any of this. And because of that, you should find the defendant guilty of all 3 counts. Thank you.
Thank you, Ms. Black. Let me have counsel approach, please.
They did a good job. She did a good job. That first closing argument though was like the like mic drop moment, you know. Very good closing. I agree. The defense attorney, I mean, look, I get what she was trying to do. She was trying to take all of the things that she knows are going to stick in the jury's mind and try to point out that like some kind of loophole interpretation of the law or the jury instructions to say that you know, yeah, this is bad, but it doesn't go against this. So, you know, I think I can see what she's doing, but not really buying it. But she doesn't have a whole lot to work with either. Here's the thing. Her going through all of these things to, you know, talk about how Ronan was so out of control and how he was so bad and how he was so this and he was so that. The things that she was talking about were all, you know, like a lot of that stuff that she's bringing up was years before. But
all right, so ladies and gentlemen of the jury, I know it's late in the day, and I know this has been a long trial that's already run over, but because of the lateness of the hour, I have additional instructions to read that I'm not going to read until tomorrow morning. That way you will be starting your deliberations fresh. We have concluded everything, though, at this point, so the next stage will be moving into the deliberation. So at this point, I'm going to ask that you come back tomorrow at 8:30 for the beginning of deliberations. I have additional instructions to read to you at that time, but what I don't want to have happen is me send you into the jury room this afternoon and there'll be a rush to judgment or a rush to deliberations because of the lateness of the hour. So I think the better form of practice at this point is to have you come back tomorrow. We'll start at 8:30. You should plan on, once the deliberations start, I typically go no later than 6 p.m. on most days. And if the jury is not able to stay until 6, then we usually end at 5 on days that are where jury deliberations are actually occurring. I never know how long deliberations are going to occur, but I do like to give my jurors some idea of what the normal workday is once deliberations start. So for you, then the process will be pretty much the same as it's been up to this point. Go home, relax, have a good dinner, good night's rest, because tomorrow will be a full and long day. You won't be out here in court. You will be in the jury room deliberating, but that will be a process that you'll experience firsthand tomorrow. Remember, during the break, don't discuss the case. You know everything about the case there is to know at this point, so more than ever, make sure you don't discuss the case with each other or with anyone else or do any kind of research, investigation, or any of the number of things that I've instructed you during the course of this trial not to do. The last thing I'll tell you is make sure you don't inadvertently expose yourself to any media coverage of this, including video or print coverage at this point. Other than that, go home, have a good evening, and I'll see you tomorrow at 8:30 in this courtroom for start time.
I see smiling.
Deputy, can you have them just come to the door? I should have told them when they need to check in tomorrow, and I didn't. So let me do that. If you can just have them come to the door. They don't have to come back out here. You don't have to file back out here. I just want all the jurors to know I neglected to tell you when to check in with the jury office. Can everybody hear me? All right, so just check in at 8 o'clock in the morning. Be up at the 11th floor at 11:15 to check in with the bailiff, and he'll bring you back into the jury room between 8:15 and 8:30 for an 8:30 sharp start time. All right, thank you. I heard one of the jurors ask that question, so I covered it. All right, thank you. All right, everyone may be seated. All right, anything else I need to address before we reconvene tomorrow? All right, court is in recess. I'll see everybody tomorrow.
Alrighty, so so here's the thing. I get the argument of you know, whatever they're saying about how he was, you know, had behavior issues and he had, you know, this and that, whatever. But but here's the thing. He's a child. So it's like shaken baby. Like, you know, it's, and yes, I realize he's not a baby, but I'm saying the actions of a child do not justify an adult breaking the law. And the way that the DA went over all of the, like, each of the, you know, in order to find guilty on this, you need to prove this. And here's how we proved this. Like the way that they did it, she did I think, a fantastic job of going through each thing and showing why that is, according to the law, reason for guilt. No matter what issues he had, the parents had a responsibility to, Simon, I see your comments. Saying that a child is a nightmare, first of all, is, I think I would lay off on the language, but I don't like calling kids names. But also, like, if they discipline him physically, they'd have been charged I don't know if you heard all of the closings, but that they literally said that, you know, physical punishment in Florida, like there are situations that are allowed. But having said that, you don't, as an adult, you don't get to parent out of frustration. You don't get to behave in a way that causes permanent mental and emotional damage on a child because you're frustrated. So it has to be up to the adult, the parent, who chose to parent this child, to fulfill those obligations as a parent and do things the right way. He may have gone to see different doctors and stuff, but they already testified that he would go to one doctor for, you know, like 1, 2, maybe 3 appointments and then go, you know, and then stop going. There are a lot of other ways that they could have gone about this. There's not a person alive who Lord, if the internet's taught me something, there's a person alive that thinks everything. But I think the overall reasonable population would agree that what the parents did was not okay. But this is beyond not okay. This is passing, like I said it the other day, you know, you have, like, here's your, you know, like, I'm, you know, like the free range moms, you know, like, and dads, like, go just be free, whatever, I'll see you sometime this week. And then there's the ones that are like super, super strict and like, you know, whatever. And everything in between here is cool, but they were over here. Like they passed that line of what is literally written in the law as to what's okay to put a child through. And if they had gotten, you know, all the way to this point and hit this wall, then that's up to them to seek outside help, not to go beyond what is acceptable behavior for a child. So I know all parents lose their crap at some point. But the fact that their other child testified that she was scared that Timothy was going to kill her brother, that's where this acceptable behavior is. It's too far. So I think that's the problem that this is. It's not about the child's behavior. It's about the parent's responsibility to react to that behavior within the confinement of the law. And so that's the issue. So I think this trial has nothing to do with the behavior of the child. This has to do with the parents crossing boundaries that are so detrimental to the child that they're against the law. So that's what this is about. All right, so that does it for today. That does it for today. I did a poll. We'll do one more real quick before we go. Okay, as a juror, what is your vote on, what was it, aggravated child abuse and unlawful imprisonment? I think that I think that the poll results earlier were everybody was thinking like between 2 to 4 hours was like the main consensus. Wasn't like 47% or something like that. All right, so not surprisingly, hello future, where have you been? Where have you been? Not surprisingly, it is predominantly guilty. I don't think that that's much of a surprise to anybody. All right, so here's the plan. What time do they say for tomorrow? Y'all know I've had 3 hours of sleep, and I'm like, you can always tell when I'm like completely sleep deprived and tired and have run out of gas because I can't get out normal words. All right, 8:30 sharp. Dang, 8:30 sharp. That's 7:30 my time. Shoot. We'll play it by ear. If we don't start right on time, it's not going to matter. They're not going to do anything. So here's the plan for tomorrow. The podcast, the Karen Reed stuff that I'm covering is incredibly involved and interesting and wild. If you haven't listened to the podcast, please listen to it. It's oh my God, there's so much work into it, but it's a good thing. There's a lot. I think tomorrow what we're going to do, because there's a lot more that's going to be happening with this case. I think tomorrow what we're going to do while we're on verdict watch, because there's nothing starting tomorrow. But I think what we're going to do is do a Karen Reed stream, and we're going to go over all of the Karen Reed stuff tomorrow while we're on verdict watch. So that's going to be our plan for tomorrow. All right, I'm going to give y'all another second or two to get your vote in. Get your vote in. There's a lot. Oh, look, I'm blurry. Hold on, wait. The power, the force, whatever it's called, whatever that Star Wars or whatever it is. I think tomorrow, because I've had no sleep, and they ain't gonna be done. They ain't gonna be done that early. This ain't gonna be less than an hour verdict, so we might start like an hour later than they are, because they're starting at 8:30. We might start about 9:30. Give me a little bit of extra time to sleep, because I haven't in so long. But we'll do a Karen Reed stream tomorrow while we're doing the verdict watch, and we'll go over a bunch of stuff and then see how that goes and watch. The next trial, well, funny you ask. There's a few that are coming up. The Dan Markle trial, well, Charlie Adelson trial, starts on the 23rd, and our jury selection, I think, starts on the 23rd. That one's not far from me at all, and I really want to cover that one. But also, Caitlin Armstrong, cyclist, starts the week after that. But I really want to cover, I think I might do Dan Markle, especially because I really want to go to jury selection for Dan Markle, since it's not far from me, and watch the jury selection stuff, and then come back and stream for the actual trial. I don't know. I'm going to play it by ear. But we've got the rest of this week, and then next week, I don't know if there's any new trials starting in between them, but I'm really interested in the Dan Markle. So we got like a week and a half until that starts. We do have Cara Rentala's sentencing next week, and the arraignment for the Tupac stuff. So that's what we got going. All right, let me end our poll. Here we go. 94% said guilty, 5% said not guilty. So that is where we stand on the poll. Not surprising. Not surprising based on, feedback of the chat and stuff. All right, so y'all have a good night. go do whatever the heck y'all do when you're not on jury duty. I don't know. What do you do? Like, what do you people do? What do you do? Pet dogs, chase llamas. Like what do normal people do for fun? I don't even like. I don't even know. All right, so wait for the next stream. Just sit here, just stand right where you are, and wait on the next stream. All right, y'all. I appreciate you so much. If you have not hit the like button, please do it. Is anybody live? Let's see. Is there anybody for us to read? Who's live? Let's see. Is RA still live? Yeah, I said chase llamas. Oh, RA ended 6 minutes ago. Oh, well. Oh, Icked Mill's live with a chase. I could send you there. Is that it? Nobody's live? What does everybody do in their... Here. Oh my gosh. I think oh. This is not good. You can tell when I am tired. Because I don't do things normal. All right. I'm going to send y'all there. I'm not going. I'm tired. I'm going to bed. But I'll send y'all there and you can watch the chase with him while we just missed RA. I feel like every single time I try to send everybody to RA. I always just miss him. All right. So we're going to, I'm going to go get some rest, and I will put the stream up so y'all can find it in a few minutes, and go ahead and set your, I'll put that on before I go lay down. So that way you can put your notifications on there so you'll know when we go tomorrow. So I appreciate y'all so much. Hold on tight. I'm going to pour you over, and I'll see y'all tomorrow.